Hearing will start now. This is CWU 94 of 2023 and OA 451 of 2022.
Sorry, yes, morning. It is CWU 94 and its related OAs, Mr. Lionel Leo, correct?
Yes, Your Honor. May it please the court.
All right, thank
Good
you.
morning, Your
Mr. Anand Noor, Mr. Andrew Flug, Ms. T. Abirami, and Mr. To Yong Xiang.
That's right, Your Honor.
All right, I have a number of you representing various parties who will come to you later. Let me just administer the Zoom allocution. So parties are reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings. And only those persons, counsel notified to court, should be present at each location, and parties should treat these proceedings as they would a physical hearing. All right, let me just check the status of the courtroom first. All right, let's see. The official receiver is not here yet, I believe, but in any event, I propose to proceed with the arguments. I suspect I will need to reserve in relation to the CWU, which means I'll probably reserve to everything else as well. And we will go through the papers for the CWU again later on if need be. So I don't think we need the OR to be present this morning at this time. All right. So, Mr. Leo, how do you propose to take this morning's various applications?
Your Honor, I propose to take the applications in terms of first updating Your Honor on what has happened since the last hearing on 7th of August 2023. So
Yes.
updating Your Honor on the progress, if any, on the proposed restructuring based on the OPNX term sheet, and in particular, apprising Your Honor of the views of the creditors. And after that, Your Honor, after showing Your Honor that in the IJM's views, this restructuring is not credible and it's not likely to result in any scheme of arrangement that will be approved by the court and the creditors, I intend then to go on to talk about, Your Honor, the issue of whether or not cryptocurrency can be a debt that can be...
We're going to the CWU proper. Right?
That's right, Your Honor. I will propose to do it in that order, but if Your Honor wants to hear the arguments in relation to the CWU first, I'm happy to do that.
I'd rather take everything in the round together, Mr. Leo.
Yes, Your Honor, that's what I was proposing to do, discuss all the issues in the round, because, Your Honor, in a sense, our position is the company is clearly insolvent. So it's really an option of either it goes into winding up, or alternatively, a JM order should be made so that the company can pursue restructuring. So it's really one or the other, and we think that all the arguments can be made in the round.
All right, no, what I meant was that I would have thought that the arguments about the cryptocurrency and the existence of that go to the CWU, so it should be part of the CWU arguments.
Yes, Your Honor, it would be.
All right. Let me hear your update first, then I'll give directions for the rest of the arguments. What update do you wish to give?
Your Honor, I just wanted to apprise the Honourable Court of where we stand in terms of the OPNX offer, Your Honor. And if I could perhaps refer, Your Honor, first to my written submissions filed on 13th of October 2023.
Yes.
And Your Honor, I was going to refer Your Honor to paragraph 48 in particular.
Yes.
And Your Honor, this is the position that was taken as of, I believe, 28th of September 2023, Your Honor. That was the date on which the IGMs had filed their reply affidavit at that time in OA 792, Your Honor, setting out the position on the proposed restructuring at that time being pursued by Mr. Lee in OA 792.
Yes.
So this was the position in terms of what the creditors thought, and in particular, the major creditors, Your Honor. At paragraph 48, we had stated, and I think the position remains the same today, Your Honor, that as far as the 5 largest creditors are concerned, there is no support at all for any restructuring based on the OPNX term sheet. The top 5 creditors hold it depends on the date at which you're looking at it, Your Honor, because cryptocurrency values are fluctuating, but they hold about in total 60% of the debts in value of the entire Hodlnaut group. And Your Honor, at paragraph 49, we speak in particular of the top three creditors. That would be Sam Trade Custodian, Algorand, and Sam Fintech, Your Honor. The top three major creditors, again, if we look at it as of the group's debts, they hold approximately 58.19% of the value of the debts of the Hodlnaut group. And in my respectful submission, Your Honor, it is the group's debts that is relevant for the purposes of this proposed restructuring, simply because what is proposed in the OPNX term sheet is a restructuring of the entire group. That means not just Hodlnaut Singapore, but also Hodlnaut Trading Limited, which we often refer to as Hodlnaut Hong Kong. So whether or not we classify Samtrade as creditor of Hong Kong or Singapore, their views need to be taken into consideration, because we appreciate there is an outstanding issue of whether they should be classified as a creditor of Singapore or Hong Kong. Your Honor, but we also at paragraph 50 take Mr. Lee's case at its highest. That means if we assume we exclude Samtrade because they could potentially be a Hong Kong creditor, and we just look at the debts of Hodlnaut Singapore, Your Honor, Algorand and Sam Fintech would then hold approximately, Your Honor, 47.4% in value of the debts of the company. And Algorand itself would hold 41.2%, Your Honor. So what this means essentially, Your Honor, is that whichever way you look at it, if there is no support from the top three creditors in value, Sam Trade Custodian, Algorand, and Sam Fintech, any scheme of arrangement is essentially dead in the water, Your Honor. It has no prospect whatsoever of succeeding. And it was primarily on this basis that the IGMs took the view that there really is no point either keeping the company in interim judicial management or making a judicial management order to consider this scheme of arrangement, because it simply cannot pass. I will go into later in my submissions why the IGMs, for their part, consider that the reluctance or opposition by the creditors is reasonable and justified in the circumstances, because there is no credibility both on the part of the directors and to a slightly lesser extent on OPNX, and because of some conduct which has led to already the depletion of the liquidation estate of the group as a whole, that these claims could well be swept under the carpet and not taken into consideration if a restructuring is done. But I'll get to that later. I'm just apprising Your Honor at this time on the position with regard to the creditors' views. Your Honor, then if I could turn to the updating on what has happened since the filing of the reply affidavit on the 28th of September, Your Honor.
Yes.
Your Honor, straight after the hearing of 7 August, there were immediate steps taken by the IGMs, and I say this, it is also on the part of my learned friends at CHP, to try to arrange a meeting with the directors and OPNX to try to figure out what this deal was, to address some of the concerns that the IGMs had on the term sheet or they considered the creditors might have had. There was some back and forth. The IGMs wanted a meeting, in particular with OPNX. There was no appetite at that time, it appeared, from OPNX for such a meeting, but there were written queries that the IGM sent to OPNX. The responses were unfortunately very high level, didn't go into detail, no supporting documentation. So that was a difficulty that the IGMs faced in terms of presenting the term sheet to the creditors, but they nevertheless sought to do so, Your Honor. But what happened then is that 1 week before the hearing, OPNX suddenly seems to have taken a slightly different view and said, okay, we can meet. So there was a meeting, Your Honor, arranged between the IGMs, OPNX, in particular, Mr. Mark Lam of OPNX, as well as the directors, Mr. Simon Lee and Mr. Zhu Jintao.
Mhm.
That meeting, Your Honor, took place on the 10th of October 2023.
Yes. Mhm.
At that meeting, Your Honor, various things were discussed. They are set out, I think, in some detail in a letter sent by Drew and Napier. I will show Your Honor that letter later. Drew and Napier, Your Honor, for context, they represent, I think they say they represent Hausen, which is a Hong Kong council that represents Mr. Zhu and Mr. Lee. And they are saying they're advising them in terms of the restructuring. That's why the letter came from Drew and Napier rather than CHP Law. But Your Honor, in essence, the terms of the deal that is proposed have not materially changed, save in one aspect. The proposed capital injection in the original OPNX term sheet, Your Honor, was a proposed injection of $30 million US dollars worth of flex tokens. At the 10 October 2023 meeting, OPNX confirmed that instead of flex tokens, what they propose to inject now is OX tokens. So that's the new token that is being issued by OPNX. I think flex tokens is a slightly older one that was used to be associated with CoinFlex, which Mr. Mark Lam was associated with, that went through a restructuring. So it's the change in the token, but save for that, OPNX did not propose any other changes to the term sheet. So the deal is essentially the same deal. The only difference is that the token is changed. So Your Honor, following that meeting, and in particular at the request of the directors wanted us as IGMs to set out their letter, what they had stated, put it before the creditors so the creditors will know what has happened at this meeting. As IGMs, we are non-partisan, Your Honor. We were fully prepared to do so. So what we did, Your Honor, is that shortly after the meeting, on 10th October, on 12th of October, Your Honor, we sent out a creditor circular, the 58th circular of the IGMs, to update the creditors about the 10th October 2023 meeting, in particular highlighting the fact that the tokens to be injected has changed from flex to OX, and we enclosed Drew and Napier's letter in its entirety. And Your Honor, that letter was, if I may say so, it was selling the deal to the creditors. It was telling them what a good deal is this, what would happen in the deal. So that was what they sought to do. It was sent out to the creditors, and in the circular, the IGMs invited comments. In particular, if any creditor had any view on the OPNX term sheet as revised, whether they supported the restructuring or opposed it, whether they supported the winding up or opposed it, and also whether they supported the appointment of the IGMs as liquidators. So those were the questions posed in the circular, and it was stated to creditors, if you want to respond by email, the IGMs will collate those responses. And Your Honor, we did so. There were responses by creditors. And Your Honor, this might be a good time for me to turn Your Honor to the second supplemental bundle of documents, which sets out the creditors' responses as well as my circular, Your Honor, or rather the IGM circular. Does Your Honor have that second supplemental bundle of documents?
Hold on, please.
Understood, Your Honor.
Yes.
Thank you, Your Honor. And Your Honor, I was going to say that that bundle of documents should be read with a new letter that we just filed this morning, Your Honor. The reason why we sent that letter was that we received 5 further emails after we filed our submissions and the bundle, Your Honor.
I don't have that before me. Can you just describe briefly what it captures?
Yes, Your Honor, I will do so. So I will describe what's in the letter. It essentially summarizes the position of all the creditors who has responded, but I will do so in oral submissions to update Your Honor.
No, yes. So just what is the summary? What is the one-liner summary, please? Okay,
Your Honor, in summary, in terms of if I might have a bit more than a line, for the 5 major creditors, none of them have responded to say they have changed their position. their position was that they opposed the restructuring, save for Algorand, but Algorand's response was that their position is the same. They oppose the restructuring and they want Hodlnaut to be wound up as soon as possible. So in terms of major creditors, they all continue to oppose. That's my understanding.
All right.
But we received, in addition, 16 other emails, Your Honor, from smaller creditors. I think many of these were retail creditors. And the summary, Your Honor, is that in terms of the restructuring, all but one oppose it, Your Honor. All but one oppose the restructuring based on the OPNX offer. And the only creditor that didn't oppose it expressly, he also didn't support it. What he stated, Your Honor, was that he would like the IGMs to pursue whatever action would yield the most returns. So essentially saying no real position, whichever is better in terms of returns. In terms of the second question about winding up, Your Honor, same thing, all but one support the winding up of Hodlnaut. The single creditor that did not state that they supported the winding up, Your Honor, is the same creditor that said, whichever way is fine as long as I get the most returns. But I say that, Your Honor, there was one other creditor that stated that they supported winding up, but not now, because their position is that crypto prices are low now. So they want winding up later.
All right.
That is the position on opposing the restructuring and supporting the winding up. The last one, again, is the same thing, Your Honor. All but one stated either that they supported the appointment of the IGMs as liquidators or did not state a position. There was one creditor that stated, Your Honor, that they opposed the appointment of the IGMs as liquidators on the basis that, alleged basis, that they lacked knowledge in the cryptocurrency markets, Your Honor. But no alternative liquidator was put forth either by that creditor or, for that matter, by any creditor, including Mr. Simon Lee.
All right.
Your Honor, so that is my update. So it does appear that in terms of where the creditors stand, the position is in some ways even stronger than it was when the liquidators, the IGMs, Your Honor, filed their reply affidavit, because there are additional parties who have responded and they have essentially taken the view that they oppose the restructuring and they want winding up as soon as possible.
All right. All right. Anything else in terms of the update, Mr. Leo?
No, Your Honor. Nothing further on the update.
All right. So you wish to proceed with the CWU application as such, correct?
Yes, Your Honor.
All right. Let's go into that.
Thank you, Your Honor. Your Honor, since we are proceeding on the CWU itself, I think then it makes sense for me to start with the issues relating to whether cryptocurrency, or rather a liability to repay cryptocurrency, is something that can and should be considered when considering whether a company is cash flow insolvent.
All right. So could you take it in terms of the elements of the winding up, please?
Yes, Your Honor. If I could refer, Your Honor, again to my written submissions, because I think I set out the relevant sections there.
Yes.
Your Honor, it's at page 8 of my written submissions.
Yes.
I'm sorry, page 9, Your Honor. At page 9, paragraph 26, Your Honor, we point out that the relevant provisions are section 125, subsection 1, subsection E, read with section 125, subsection 2, subsection C of the IRDA, Your Honor.
Yes.
In particular, the court may order the winding up of a company if E, the company is unable to pay its debts. And subsection 2C says a company is deemed to be unable to pay its debts if it is unable to pay its debts and it is proved to the satisfaction of the court that the company is unable to pay its debts. And in determining whether a company is unable to pay its debts, the court may take into account the contingent and prospective liabilities of the company.
Right.
So, Your Honor, the issue I think that is being engaged in this case, and it's the only argument that has been raised by any creditor as to why Hodlnaut should not be wound up, is that the contention by Mr. Lee, and I think it is shared by Mr. Tu Chin Tao, he is, I think, a very, very small creditor and is a director of a creditor. But in essence, Your Honor, the only argument that's been raised as to why there shouldn't be a winding up is that the company allegedly is able to pay its debts, because the argument goes, the word debts only refers to fiat currency debts, Your Honor.
So at this point, can I just confirm with you that otherwise all the papers and requirements are in order?
Yes, Your Honor, they are all in order. Does Your Honor require me to bring Your Honor through that?
No, just state it, summarize it briefly so I can turn to the OR just to confirm that.
Yes, Your Honor. Your Honor, I'm sorry.
Sorry, who's that?
My apologies, Your Honor. The papers are in order.
Sorry, Mr. Chandra, I cannot hear you. The audio is. Yes. Turn it on the audio. Can you try again, Mr. Chandra?
Yes, Your Honor, the papers are in order, Your Honor.
Sorry, there's a lot of stuff. Annie, what's your reception like?
My reception is fine.
Sorry, hold on. I'm getting started from everyone. Leo, hold on. Everyone else. Leo, can you get,
I think that Mr. Chandra, I guess the
hold on. Annie, stop, please. Mr. Leo, can I test yours?
Yes, Your Honor.
Okay, I'm clear on Mr. Leo. Mr. Chandra, can we just come to you later first and while I sort out with Mr. Leo? All right, Mr. Leo, can you please state whether you think the papers are in order?
Yes, Your Honor. The papers are in order. The CWU memorandum, it was filed on the 22nd of June, 2023, Your Honor.
Mhm.
And Your Honor, I think through the static, I had heard that Mr. Chandra had confirmed the papers are in order, at least
All
from
right,
his.
I couldn't hear that, but you just go to your portion first. I'll come back to Mr. Chandra after this.
Sure, Your Honor. Your Honor, other than the memorandum of companies winding up that was filed on the 22nd of June, Your Honor,
Yes.
the winding up applications were duly published and advertised in the Business Times on the 21st of June, 2023,
Mhm.
and in the Government Gazette on 21st June, 2023 as well, with the Business Times being an English newspaper circulating in the Republic of Singapore.
Yes.
Your Honor, the memorandum of advertisement or gazetting was filed on 22nd of June, 2023, Your Honor.
Mhm.
The affidavit of service of Azhar bin Ridwan, verifying service of the winding up application, and the supporting affidavit on the official receiver and on the defendant was affirmed on 29 May 2023 and filed on 29 May 2023, Your Honor. The claimants have deposited, Your Honor, the prescribed sum of $10,400 with the official receiver on 12th of May 2023. The payment summary, Your Honor, was exhibited in the first affidavit of Aaron Low Cheng Lee, dated 22nd May 2023, filed 29 May 2023. Your Honor, Mr. Aaron Low Cheng Lee and Ms. E. Ming Yan Angela, the IGMs, Your Honor, are licensed insolvency practitioners of EY Corporate Advisors. They have consented in writing on 19 May 2023 to being appointed joint and several liquidators of the defendant in the event that the defendant is wound up by the court. And as Your Honor, I have mentioned, there are, I think, no other applications or requests, no other alternative liquidators being put forth.
All right.
Does Your Honor require any other clarification?
No, I understand. Thank you. All right, Mr. Chandra, let's try again. Are you able to confirm that, please? Mr. Chandra, you're muted, sorry.
Yes, Your Honor. I can confirm that the papers are in order, Your Honor.
All right, I heard paper sign. All right. All right. All right. So for those opposed, can you switch off? Yes, thank you. So for those opposing, Representative Mr. Chu and Mr. Lee, are you taking any issues about the papers? Mr. Kang?
No, Your Honor.
All right. Mr. Kwa?
No, Your Honor.
All right, thank you. All right. All right. So I'll proceed to the substantive arguments. Mr. Chandra, you're given leave to depart the hearing if you wish. I don't wish to detain you. For the other parts, I'm likely to reserve judgment. I'll ask Mr. Leo's firm to update you on the outcome, but I'm likely to reserve the winding up decision on the winding up application. All right. Thank you. All right, Mr. Leo, coming back to you then. Let's proceed with the substantive arguments in relation to CWU. Thank you.
Yes, Your Honor. Your Honor, I was at page 9 of my written submissions, and I'm making my submissions as to why, Your Honor, a liability to repay cryptocurrency is something that should be considered when considering whether a company is insolvent, Your Honor. Your Honor, I think there is no real dispute that if cryptocurrencies are an asset and a liability to repay cryptocurrency is considered to be a debt, that Hodlnaut cannot pay its debts as they fall due. I don't think Mr. Lee disputes that. The dispute is that, Your Honor, I think Mr. Lee's contention is that in considering the liabilities of Hodlnaut, those liabilities to be confined to liabilities that are denominated in fiat currency. And given that 99% of the liabilities of Hodlnaut are denominated in cryptocurrencies because of the nature of its business, Mr. Lee's submission is that Hodlnaut can pay its fiat currency debts, so it is not insolvent. Your Honor, I will come to the text of the IRDA because I think that is probably the most important, together with the Court of Appeal's decision in Sun Electric.
Yes.
But as a preliminary point, Your Honor, I would say that the position taken now by Mr. Lee is a little ironic because Your Honor will recall that when they were in control, Mr. Lee and Mr. Tzu were in control of Hodlnaut. They were the parties that actually caused Hodlnaut to file for interim judicial management and to apply for a judicial management order. And in the affidavit filed in support of that application, the position taken was that Hodlnaut would likely, in the near future, at that time, be unable to pay its debts as they fall due. But now their position seems to be different. But, Your Honor, coming to the text, I already read to Your Honor the text of 1251E. Admittedly, the words used there is unable to pay its debts. But, Your Honor, the IRDA specifically says that at 1252C, that in considering whether a company is unable to pay its debts, the court must take into account contingent and prospective liabilities of the company. So it is already expressly envisaged that the word debt is not confined in the way that sometimes we think of action in debt, where it's action for a fixed sum and no concepts of remoteness or mitigation of damage applies. It doesn't work that way. And Your Honor, this is the same point I make in terms of my learned friend's citation of different statutes, such as the Digital Payment Services Act, or it's not relevant for the purposes of construing a term that has a specific meaning in the IRDA, Your Honor. So, Your Honor, my respectful submission is that in looking at the word debt, it is expanded by virtue of 1252C to include liabilities. And it is in fact not just current liabilities, but even contingent and prospective liabilities. And Your Honor, that is also evident from section 218 of the IRDA, which is discussed at paragraph 30 of my submissions, Your Honor.
All right.
At section 218A, Your Honor, the IRDA sets out debts that are provable in judicial management or winding up. So again, the word used is debts. But when defined in section 2182, the statute provides, subject to this section and section 203, the following are provable where a company is in JM or an insolvent company is being wound up, says any debt or liability to which the company is either subject to at the commencement of the winding up or may be subject to after the commencement of winding up by reason of an obligation incurred before the commencement of winding up. So again, the reference point when we are talking about insolvency, when you look at the words debt, it is not the same use of the word in other statutes. It is talking about debts or liabilities. And Your Honor, we would then have to turn to Section 2 of the IRDA, which defines the term liability. And that's discussed, Your Honor, at paragraph 32 of my written submissions. And here, Your Honor, the definition of liability means a liability to pay money or money's worth. And then it goes on to a very broad definition of regardless whether such liability is present or future, certain or contingent, of an amount that is fixed or liquidated, or that is capable of being ascertained by fixed rules or as a matter of opinion, and includes any such liability arising under specific laws, Your Honor. So, Your Honor, my submission is that this is an extremely wide definition that defines liabilities as a liability to pay money or money's worth. And Your Honor, at the base, my submission is that even if we don't use the word money's worth, a liability to repay crypto is in some ways a liability to pay money. The reason I say that, Your Honor, is that if a party owes another party an obligation to repay crypto, say in Bitcoin, if he's unable to repay the Bitcoin, then what he'll be liable to do is that the secondary obligation of damages kicks in to put him in the same position that he is able to buy the Bitcoin. And Your Honor, in this case, we are not talking about cryptocurrencies that are obscure. The vast majority of the cryptocurrencies at issue, Your Honor, are Bitcoin, Ethereum, USDC, USDT. Your Honor, these are established cryptocurrencies. You can just change fiat currency into USDC or USDT and buy it. So, Your Honor, to say that just because a liability to repay crypto is at first a liability to pay back the specific cryptocurrency, therefore it no longer is a liability to pay money, Your Honor, I think it's not correct, because if you don't pay the Bitcoin, your liability is to pay fiat currency, to put the other party in the position that they can buy the Bitcoin. So, Your Honor, even if it's just liability to pay money, I think the case is made out. But, Your Honor, the statute's even wider. It talks about liability to pay money or money's worth. And, Your Honor, I think that the definition, Your Honor, is meant to encapsulate anything for which a judgment can be given. So, in a sense, if, for example, the liability is to deliver a car, the car has a monetary value, and if you don't provide the car, you have to pay damages in money's worth. And, Your Honor, that is my submission of what the section on its face provides. At this point in time, Your Honor, I just wanted to deal very quickly with, I don't need to turn Your Honor to it. It is a submission by my learned friend that talks about a specific section of the IRDA which talks about the word debt. I just want to deal with that since we are talking about the IRDA. If Your Honor wants to look at it, Your Honor, it would be in Mr. Lee's submissions, also filed 13 October 2023.
Yes.
In particular, paragraph 23, Your Honor, I can read it out for Your Honor. Under section 288, subsection 1 of the IRDA, debt is statutorily defined as any debt or any liability to pay money that is unsecured, present, certain, and of an amount that is fixed or liquidated. Your Honor, my simple point to that is that that definition doesn't apply, because it is a specific definition, Your Honor, that applies only to Part 15 of the IRDA that concerns the debt repayment scheme. Your Honor, on the face of section 288, it says, in this part, which is part 15, unless the context otherwise requires, debt means, and then it provides for the definition stated in my learned friend submission. So, Your Honor, my point is that that part specifically, due to the debt repayment scheme, the nature of that scheme, it sought to define debt in a specific way. In no way should that impact the definition in section 1251E, which is specifically discussed at 1252C and must be seen in the light of section 218 of the IRDA, Your Honor. So, Your Honor, that's my submission on the text of the IRDA. But, Your Honor, my case, I think, is even stronger when seen in the context of the Court of Appeal's decision in Sun Electric, Your Honor. Sun Electric, Your Honor, if I could turn Your Honor to the decision, and again, I will try to be brief. I won't discuss the whole decision, but just the relevant parts. Your Honor, that's at the supplemental bundle of authorities of the IGMs at tab 8.
Yes.
Thank you, Your Honor. And Your Honor, I refer to paragraph 65 to 67, Your Honor. That's at pages 214 and 215 of the bundle.
All right.
And Your Honor, I would just highlight some salient points from these paragraphs that I think fortify the approach to take in this present case, that cryptocurrencies, a liability to repay cryptocurrencies must be taken into account. At 65, Your Honor, the court finds we thus hold that the cash flow test is the sole applicable test under section 2542C of the Companies Act. For clarity, the cash flow test assesses whether the company's current assets exceed its current liabilities such that it is able to meet all debts as and when they fall due. And Your Honor, right at the outset, I make a commonsensical point, which is that if cryptocurrencies that are owned by Hodlnaut are an asset, and in particular a current asset if they are Bitcoin or Ethereum, because they can be easily converted into fiat currency like US dollars or Singapore dollars, you can do it online. It is a current asset because it can be converted almost immediately into something that can be used to repay fiat debts or cryptocurrency debts. It is a current asset. If on the one hand, you're looking at current assets, cryptocurrencies are taken into account, but you say that, oh, when it comes to a liability to repay crypto, you don't take that into account. Your Honor, I think that is fundamentally inconsistent and, might I say, absurd. And if Your Honor will see later on at paragraph 67, the Court of Appeal in fact says that the whole purport of Sun Electric was that to allow a flexible time frame in considering what debts are due and what assets may be realizable, a flexible time frame to prevent absurd results. And in my submission, if on the one hand you say cryptocurrencies, if you own it, they are current assets, but if you owe obligations to repay it, that's not taken into account. That is absurd. Your Honor, I then move on to paragraph 66 of Sun Electric, and in particular, the quoted paragraph, Your Honor, that's a quote from the case of Ko In Tong, quoted with approval. Your Honor, the Court of Appeal quotes this paragraph, which says, it should also be noted that the courts adopt a commercial rather than a technical view of insolvency. And therefore, it says, thus, while the phrase is unable might be thought to refer to the inability at the relevant time to pay debts which have then fallen due, its conjunction with the phrase as they fall due indicates a continuous succession of debts rather than a calculation of debts existing on any particular day. And this is important, Your Honor. The essential question is whether the company's financial position is such that it can continue in business and still pay its way. The court therefore has to consider whether any liquidity problem the company may have is purely temporary and can be cured in the reasonably near future. And at 67, Your Honor, the court then finds it is necessary to have a flexible time frame in mind when assessing the current assets and liabilities of a company, because a consideration of only present debts and assets could potentially lead to absurd outcomes. And Your Honor, I think what we can take from paragraph 66 and 67, Your Honor, is that the Court of Appeal has said we have to take a commercial view of insolvency, not technical one. I think what my learned friend is submitting on behalf of Mr. Lee is a highly technical view of insolvency that leads to absurd outcomes. That you can take into account cryptocurrencies if you own it as a current asset, but in terms of ability to repay, you don't take it into account. That's not commercial, Your Honor. That's a technical view. And secondly, Your Honor, the Court of Appeal has emphasized that what is really crucial is the company in a position to continue in business? Your Honor, it is my respectful submission that it is very clear that Hodlnaut cannot continue in business. It is not in a financial position to continue in business. Its entire business, Your Honor, is that of essentially a cryptocurrency bank. It takes deposits of cryptocurrencies and repays them upon a withdrawal request with some interest. Your Honor, it cannot repay its customers the cryptocurrencies that they have deposited with Hodlnaut. If there is no winding up or judicial management, this company simply cannot continue in business. So applying that commercial view of insolvency and taking into account the fact that you can't on the one hand have cryptocurrencies as assets, but not as the repayment, the liability to repay them are not considered in liabilities. It is my respectful submission that Sun Electric clearly stands for the proposition that you really have to look behind these kinds of technical arguments that I think my learned friend is raising. So that was, Your Honor, my submission based on Sun Electric. Your Honor, I was then going to say that in a sense, Your Honor doesn't have to decide the issue of whether a liability to repay cryptocurrency is a liability to repay money. That's not necessary because ultimately the statute uses money or money's worth. But Your Honor, I accept that the case authorities in terms of, and I'm talking about foreign case authorities, in terms of whether or not cryptocurrencies are money, there is a divergence. My learned friend, Mr. Lee, has cited some authorities and commentaries about cryptocurrencies not being considered as money. I had highlighted, Your Honor, in particular at paragraph 35 of my written submissions that at least in the United States courts, they seem to have gone the other way. And they've taken the view that cryptocurrencies can fall within the definition of money. And in particular, the reference point that the courts there looked at was that cryptocurrencies, and in particular ones like Bitcoin, which are established, they are generally accepted as a medium of exchange, a measure of value, or a means of payment. And Your Honor will know that in the case of Bitcoin, it's actually legal tender in El Salvador. So while I don't think my learned friend will contest that foreign currencies fall within the definition of money, insofar as Bitcoin is concerned, if it's legal tender in El Salvador, that does support the interpretation that at least for Bitcoin, it is equivalent to a foreign currency and ought to be recognized as money. But as I had submitted earlier, Your Honor, there's no need to go that far to find whether or not cryptocurrencies are money or not. In this case, we are really looking at the definition of debt, which incorporates the definition of liability, which then gives a very wide definition to say a liability to either repay money or money's worth. So we don't have to go that far. Your Honor, it then leaves me to deal with two final points. One is the reliance by Mr. Lee on the judgment of the Honorable Vinod Kumaraswamy in Algorand Foundation versus Three Arrows Capital Private Limited. That's one of the points that I have to address, Your Honor, on. Your Honor, I didn't propose to go into the text of the judgment, which I think is not reported and is not in a written judgment. It actually is part of the notes of the court. But if Your Honor wants to see that, it is found in my bundle of authorities. Just give Your Honor the reference. I wasn't proposing to turn Your Honor to the actual judgment. It's at tab 3, and in particular at page 98 to 100 of the bundle, Your Honor. Because I think, Your Honor, it suffices for me to say that that decision is clearly on its face restricted to a specific question of whether or not an obligation to repay cryptocurrency can be used for the purposes of triggering the presumption of insolvency by the sending of a statutory demand. And it's actually not even the same word. His Honor in that case was interpreting the word indebtedness. And Your Honor will know that the paragraph of the IRDA that talks about a presumption of insolvency, there is a specific monetary threshold of 15,000 Singapore dollars. So the considerations in that case were very different. And what it appears His Honor was deciding in that case is simply that if a party is owed an obligation to be repaid cryptocurrency, it cannot use that in a statutory demand to trigger the presumption of insolvency. It shouldn't be extended to a case like this, where we are not relying on the presumption of insolvency, but this honorable court has the full information, in particular through the various interim judicial management reports about the current assets and current liabilities of the company. And in that case, really, the governing case is Sun Electric. And we should be looking at current assets versus current liabilities, looking at a flexible time frame, using a commercial rather than technical view of insolvency. That's the way it should be approached, not governed by this particular case, which is very specific. And in fact, Your Honor, in this case of Algorand Foundation versus Three Arrows Capital, which I think my learned friend, Mr. Chan, is quite familiar because he was counsel in that case. Your Honor, in that case, Your Honor, it's actually in the order of court. Justice Kumarasammy actually recognized that Algorand was a creditor within the meaning of the IRDA. And in doing that, His Honor had looked at 218 of the IRDA, which I had shown Your Honor earlier, and found that where it comes to a liability to repay crypto, you are a creditor. So in some ways, it does appear that His Honor would have shared the view that if you are not relying on the presumption of insolvency, but instead looking at whether holistically a company is able to pay its debts, that you should look at things such as a liability to repay cryptocurrency. So it is my respectful submission that case actually doesn't stand in the way of my submissions that a liability to repay cryptocurrency is something that should be considered when considering whether a company is insolvent. Your Honor, those were my points with regard to this particular issue. If I could just a moment, Your Honor, to check with my colleagues if I've missed out something.
Yes.
And if Your Honor had any questions, obviously, I'm happy to take them.
I think at this point, I should also just highlight that I propose to deal with the issue of the winding up first, and then give interim orders as required for all the other things that might be associated. So as I indicated, I'm likely to reserve this issue. So I want the arguments to be primarily about the CWU.
Understood, Your Honor.
All right. Anything else, Mr. Leo?
Your Honor, my colleague had reminded me that, Your Honor, I do have to also deal with the argument about the withdrawal that was raised by Mr. Lee.
Yes.
Your Honor, for that, I was going to have to trouble Your Honor to turn to a different set of submissions. The reason for that simply is that in Mr. Lee's affidavit, In this application, he didn't refer to that, but he did previously. So we hadn't thought that he was still relying on it. We didn't deal with it in this set of submissions, but I had already dealt with it. So, Your Honor, I was going to refer to my written submissions dated 31st July 2023.
Yes.
That's a red spine bundle.
Yes.
And Your Honor, we had dealt with the issues relating to a withdrawal halt at paragraphs 22 all the way to 34, Your Honor, of the submissions. I am not going to go through all of them. I was just going to highlight several key points. Your Honor, this argument about a withdrawal halt, Mr. Lee says they relied on clause 10.3 of the company's terms of use to halt withdrawals. In his words, it was a temporary halt. Your Honor, what we are really saying is that that withdrawal halt surely cannot be something that prevents creditors from applying to wind up the company. And I perhaps just need to highlight two arguments. The first one, Your Honor, is at paragraph 28 of the submissions. And this argument, Your Honor, is that on its face, reading the language and also considering the commercial logic, is that a withdrawal halt doesn't mean that there is no liability to repay cryptocurrencies. The moment a customer seeks to withdraw his cryptocurrencies, he's owed a liability to be repaid them. If there is a withdrawal halt, what it does, Your Honor, is simply suspend the process or procedure by which the user may be paid. It cannot be that by doing a withdrawal halt, you somehow either erase or prevent liabilities from accruing. Your Honor, that would be a commercially absurd outcome.
But sorry, Mr. Could this be then circumscribed in some way under the contract between the parties? For example, I mean, withdrawal halts are fairly commonly provided for example, is hedge funds and other investment vehicles. So in that kind of situation, assuming we're dealing with entities that can be wound up, would there be any room for the parties to agree amongst themselves that this will not actually amount to the creation of a liability if a withdrawal halt is imposed?
Your Honor, in principle, I agree that it may be possible, but it is my respectful submission, firstly, that if that is the case, and that ability, or rather that interpretation actually prevents customers from applying to wind up a company, it would need to be in very clear words. And the terms of the actual contract must be able to support that interpretation, because it is not an interpretation that is reasonable unless those clear words are used. And Your Honor, I think the words in 10.3 are not that do not provide specifically for that. So my submission is that it shouldn't be the case in this case.
And nothing else in the contract that would have that effect either?
Yes, Your Honor. I think there's nothing else in the contract which would suggest that there would be such a draconian right. And Your Honor, that actually ties in with the second point I thought I wanted to highlight, which is that while a withdrawal halt has a place in business as usual, where the company is still operating, it means a non-insolvency situation, it clearly cannot be intended to have application when the company itself applies to put itself into judicial management. Because once it applies to put itself in judicial management and asks for an interim judicial management order, it is essentially taking the view that it can't pay its debts going forward and is giving up control of the company to third parties who then have to manage the assets of the company. In such a situation, it would be unlikely that the customers would have intended that, notwithstanding the company going into IJM or JM, they still cannot prove their liabilities in the JM or in a winding up. Your Honor, that would not make sense. And that's why I say that on the face of the language used, it would be a stretch to say that a withdrawal halt means liabilities are not due. The more correct interpretation, in my view, more sensible one is that it simply suspends the procedure from which you can take out the liability, or rather take out the cryptocurrency, when the company is operating business as usual. And in this case, it wasn't creditors that put the company into JM. It was the directors who did so themselves. So, Your Honor, it is my respectful submission that Mr. Lee cannot rely on the withdrawal halt to say that liabilities are not due. That would not be correct. And with that, Your Honor, I think I have dealt with the submissions in relation to CWU 94, save for the point that I think Mr. Lee also makes an argument that CWU 94 shouldn't be granted for now by the court exercising its discretionary powers because there is this OPNX offer. So it shades into the issues relating to OA 451. If Your Honor wanted me to address that, I could do so now.
I mean, just deal with it in terms of the discretion point at this time.
Yes, Your Honor. Your Honor, I accept there is a discretion to not wind up the company at this juncture. But Your Honor, if Your Honor is going to exercise that discretion, my respectful submission that it should be guided by whether or not there is a real prospect of any scheme of arrangement being approved, simply because that is the only purpose of judicial management that my learned friends have raised in terms of a reason for the company to not be wound up. So, Your Honor, again, it comes back to that point of, is a scheme even viable? And if the creditors don't support it, be it major creditors or retail investors, they don't support a scheme of arrangement, then there is no point in a sense, prolonging the pain. And Your Honor, I had wanted to read a number, just one or two emails from the creditors, because it does show, Your Honor, that not just the major creditors who have counsel who speak for them, even the retail creditors, Your Honor, they have good reason why they want this company liquidated. And in short, Your Honor, this company has been in interim judicial management for more than a year. There is the time value of money or cryptocurrency. These users basically are saying they want to be paid as soon as possible. They're not interested in this restructuring based on a illiquid, thinly traded token that could potentially be worth a little bit more, a little bit less. They are not interested in that. They're saying, in terms of, do I get it back faster, or do I get maybe 5-10% potential upside? They want it back as soon as possible. And secondly, Your Honor, they don't consider that OPNX or the directors who are leading the restructuring attempt are credible. So that means they don't even believe that this deal is even going to happen. So it's both, if the deal happens, we don't want it, but we don't even believe it's going to happen. We think it's a dilatory tactic. We've already been kept out of our cryptocurrencies for 1.5 years. We really don't want this to drag on and on. That is what they're saying. And Your Honor, in my respectful submission, that is something that does hold some, that argument has force, Your Honor. And if Your Honor would permit me, could I show Your Honor a number of those emails?
All right.
Your Honor,
Wait, is it in your affidavit or is it in the letter?
Your Honor, it's in the second supplemental bundle of documents. Because they came in after our reply affidavit, so they're not an affidavit. But I'm happy to have an affidavit filed, Your Honor.
All right. All right. I see the letters, so I don't think you need to go them fully. You can just summarize what you make out of it.
Yes, Your Honor. I'll be quite brief on this. Your Honor, I just take Your Honor through the bundle. Page 4 and 5 is a circular, Your Honor.
Yes.
That's what we send to the creditors.
Yes.
Your Honor, pages 6 to 9 is Drew and Napier's letter. That's what they sought to set out what was discussed on 10 October, in particular trying to persuade the creditors that, you know, this deal has some prospects. Your Honor, the creditors' emails are from page 10 all the way to 25. And Your Honor, I'm just reading off some of them. For example, at page 10, one of the creditors says, I believe the proposed term sheet and injection of funds from OPNX is in no way beneficial to the creditors. Given the detailed information provided up until now, I firmly believe that this entire engagement with OPNX is not above board, given the non-transparent and adversarial manner of communication from the directors. I'm strongly in favor of winding up the company and appointing the IGMs as liquidators of the company. Your Honor, page 14, another creditor says, I've been patiently awaiting return at a minimum 25 to 30% of my over 12K deposit into Hodlnaut. I do not agree with any restructuring plan. As far as I see it, all these hearings and meetings are eating into my hard-earned crypto savings. The directors have already lost enough of my investment. Flex or OX tokens are not capital injection. Please stop directors from wasting any more of my funds with their ridiculous restructure plan. Your Honor, it goes on. They are all of the similar nature, Your Honor, because as I had mentioned in my summary, all but one oppose the restructuring. All but one support liquidation. And Your Honor, I think this stands in stark contrast to Mr. Simon Lee initially saying, oh, I got 570 creditors supporting my OA 792 moratorium. The question is, where are all those creditors? I had mentioned in my submission previously that a lot of the support could well be illusory because what Mr. Lee had emailed the creditors at that time was that there was going to be a capital injection. He didn't say it was in flex tokens. And so creditors rightly may have thought, oh, if it's cash, I can consider supporting it. Obviously, this 570, Your Honor, is a drop in the ocean, even if we consider them. There are 16,000 over users and creditors of Hodlnaut. And as I mentioned, Your Honor, without the major creditors, there's no deal to be done. But I wanted to say that even that 570, they seem to have gone away, and even if we count them, they're not going to make a difference. So that's what I wanted to say, Your Honor, and perhaps at this point in time, I could rest on my submissions, unless Your Honor had further questions for me.
All right, not at this time. Thank you, Mr. Liu. All right, Mr. Kwa, Mr. Kang, I'm going to stand down for a few minutes. Can I propose then I'll take Mr. Kwa for Mr. Simon Eric Lee first, and then I'll turn to Mr. Kang for Mr. Chu after that. And then I'll round up with anyone else who wants to chime in thereafter. All right, we'll take about a 5-minute break or so at this time. All right, thank you. Annie?
We're resuming the hearing now.
Right, if everyone is back, let me then begin with Mr. Lee's counsel, Mr. Kwa.
Good morning, Your Honor. Grateful. Your Honor, I will be covering 4 broad points in my reply to Mr. Liu. The first is to address the main argument that cryptocurrency claims are not debts for the purposes of the IRDA. And in this relation, I will be dealing with the question of whether liability, the word liability under the IRDA, is of a wide or narrow definition. The second point, Your Honor, is in relation to the argument of gating, for which we say that liabilities or the cryptocurrency liabilities do not become due, and the cash outflow required by the company can be covered by the cash assets of the company. The third argument, Your Honor, this will be a brief one, is that the court should exercise its discretion not to wind up the company because of the ongoing restructuring. And the final point, Your Honor, is my argument on the appointment of alternative liquidators to the current IGMs.
All right.
On the first point, Your Honor, on the question of whether cryptocurrency claims are debts for the purposes of IRDA, I make the simple point, Your Honor, that in insolvency cases, there is a degree of technicality to the way things are done. For example, why do statutory demands need to be unpaid for 21 days rather than 20 days? And I say that there is a level of technicality that's inherent in the law and procedure. I will first cover various statutes, as well as then 3 cases in my oral submissions, Your Honour.
Mhm.
The first point simply is that Parliament has specifically and deliberately legislated for debts as defined in the IRDA to be monetary debts. And cryptocurrency is not money.
Mhm.
The IRDA in section 288, where I concede it refers to the debt repayment scheme, it does define debt. And this is the only place in the IRDA where debt is defined. It is defined as a liability to pay money. And I highlight the word money.
Mhm.
And my argument is that, Your Honour, if this word debt is defined as a liability to pay money, it should be used in the same way across the rest of the statute in the IRDA. And this is relying on the presumption raised by the case of Tan Cheng Bock, which I referred to in tab 10 of my bundle of authorities, if Your Honour has that.
Yes.
At paragraph, I mean, this is the case where it deals with the question of the presidency and the counting of cycles before the president.
We refer to it a lot. You can take it that I'm aware of the requirements. What do you
Yes.
wish to be part of it?
I just asked Your Honour to turn to paragraph 58,
Mhm.
C, where there is an argument made as to what the office of president means. If you look at C1, Your Honour, this is at page 179 of my bundle, at page 874 of the case.
Yes.
It says on the 3rd line of part 1 is that where the identical expression is used in a statute, and here, of course, all the more so used in the subclause of a section of the statute, it should presumptively have the same meaning. This is a rule of interpretation rooted in simple logic. If Your Honour goes down a few lines after the case of Madras Electric, it says, unless we are satisfied that Parliament did intend that the identical expression could mean 2 different things, the presumptive view would be that the condition stated there would be assessed by reference to those eligible for and holding that office under the Constitution. So simply put, Your Honour, the presumption is that a phrase or a word used in a statute should be interpreted in the same way as the rest of the statute. And that's the argument I've been making, Your Honour, for the word debt in section 288 of the IRDA to apply as well to section 125, which relates to the winding up provisions of the IRDA. In fact, Your Honour, I go on slightly further, and you would see, Your Honour, that if you look at the definition of liability, which my learned friend says to it, you have to take a very commercial view based on the Sun Electric case. Your Honour, if the general interpretation of the word liability here is consistent with what I have said, it is the interpretation of a debt, which is that liability means a liability to pay money, I emphasize the word money or money's worth. So essentially, Your Honour, the question for the court to determine is whether cryptocurrency, a claim in cryptocurrency, is a debt.
All right. So, Mr. Kwok, if I can take you on that point.
Yes.
Let's move away from crypto. Let's say we're dealing with a wine brokerage or a wine vault company of some sort, or something dealing with assets. So if they deal with assets, the customers all hold supposedly bottles of interest in bottles of wine, you hold specific bottles of wine with the company, and the company's only contractual obligation is to deliver the bottles of wine, but for some reason they can't. Does that mean there's no liability in money?
Yes, I would say that there's no liability in money until such time a judgment is rendered by the court determining what the quantification of the damages incurred is.
So basically, if something happens to the wine, let's say there's no fault, the wine gets destroyed, until such time as the customers get a judgment from the court, the company basically is not liable for the purposes of IRDA, and therefore would not be on the verge of insolvency until such time as the court makes such an order.
Yes, Your Honor. And the point simply there is that the claim that is made is not a claim in debt. It is a claim in damages for which there is a question of quantification of loss. And therefore, until such time the judiciary decides what the quantification of loss is and crystallizes the judgment into a debt. Or
Even if it's very clear what the amount owed, let's say it's very clear what the bottles of wine would have cost on the market, and any uncertainty is in a rather small, insignificant amount, you would say that until the court pronounces, there's no liability for the purposes of order.
Yes, Your Honor. Of course, I mean, I think Your Honor has given a fairly uncontroversial case, but I think there are other situations where the quantification of the loss may be a big issue, and therefore that's why the judge needs to make a decision as to the circumstances and specific facts of the case before it determines whether a claim in damages should crystallize into a certain debt.
Doesn't ERDA give us that ability to quantify in terms, at least, of the court actually looking at the situation and looking at whether there's evidence made out that the company is cash flow insolvent?
No, Your Honor. And the reason for saying that, Your Honor, is we have to construe what the Court of Appeal in the Sun Electric case has said very strictly, because this is a power to wind up a company, which is a very draconian power. And until such time, Parliament legislates to expand the scope of the power to wind up a company based on what I argue is stated in statute and in existing case law. Your Honor, the court is, with respect, not able to determine or quantify the damages of a claim in and of itself to determine whether the company is unable to pay its debts as they fall due under Section 125.
What are you saying here? That in other words, I can't make any such finding until there's a lawsuit in relation to the cryptocurrencies here?
Yes, Your Honor. I believe that will be the case because, especially in our case, the question of gating is an issue which is live as well. And there's a question as to whether there is any debts that have crystallized as the result of any cryptocurrency claims, for which, Your Honor, just to be clear, there is no evidence before Your Honor in any affidavit stating that any user has sought to withdraw his or her money from the exchange, which therefore, under the terms of use in the Hodlnaut Group's terms of use, provides that such a claim then does not crystallize as against the company if there is no such withdrawal request that is made.
So even if, let's say, which is not the case here, the cryptocurrencies held for some reason fall to zero, it's very obvious that in the market there is zero. You would say that based on the contractual documents here, there's no cash flow insolvency.
Yes, Your Honor. And I think that this strict and narrow interpretation, or rather, maybe I would say a technical interpretation, is consistent with the way that Parliament has decided to legislate, because there are knock-on effects, Your Honor, on other statutes as well, and the implications of what the court, in the context of ERDA, would decide as to whether or what is the nature of cryptocurrency, and whether such claims become debts.
All right, carry on with the rest of your submissions.
Yes, Your Honor. So, Your Honor, I think there are another 4 statutes apart from ERDA where the term debt is defined similarly to what I had said earlier. The Debt Collection Act, Your Honor, Section 2, defines debt, again, as a monetary obligation owed by the debtor. Not controversial. The Payment Services Act, Your Honor, and here it is, I guess, the most recent act which considers what the terms money should mean. The interpretation of the word money includes e-money, but excludes specifically any digital payment token and any excluded digital representation of value. And it's very clear in the legislation in the Payment Services Act that cryptocurrency falls into the definition of digital payment tokens. So therefore, under the Payment Services Act, money specifically excludes cryptocurrency. So if Your Honor draws the link back to the IRDA, where the debt is defined as a liability to pay money, and money does not include cryptocurrency, therefore, the conclusion is that a cryptocurrency claim is not a debt. Your Honor, there are two other references which I didn't refer to in my written submissions. However, I raised it here in oral submissions. The GST Act itself, Your Honor, Section 2, capital A, in the context of determining whether GST should be applied to cryptocurrency-related transactions. Again, it refers specifically that in the definition of digital payment token, it says it does not include money. And in the Rules of Court 2021, Order 22, Rule 1, Your Honor, there is a definition of movable property. And interestingly, in this definition of movable property, Your Honor, debt and cryptocurrency are separately provided for. It says in the definition in Order 22, Rule 1 of movable property provides that it includes cash, debt, other forms of money, as well as cryptocurrency or other digital currency. So the fact, Your Honor, that debt and cryptocurrency are dealt with separately, I think it's an indication, Your Honor, that statute or parliament did intend for cryptocurrency, or rather for debts, to not include cryptocurrency. Therefore, the presumption, Your Honor, that I raised in relation to Tanjung Bok, of course, that is within the same statute, but I believe that there are statutory canons which provide that similar provisions or similar words used across different legislation should similarly be given the same interpretation.
All right, carry on, please.
Your Honor, I refer then to three cases, which I'll go through in some detail. Your Honor, the first case is the case of Tan Thiam Hock, the O'Laughlin Industries. This is at tab 8 of my bundle.
Oh, yes, hold on. Okay. Sorry, yes, tab 8.
Of my bundle of authorities, Your Honor, dated 13th October. Tab 8 refers to the case of O'Laughlin and Tan Thiam Hock as a 2020 decision of the High Court.
Of the Assistant Registrar.
Yes, Your Honor, that's right.
Do you have something else?
Well, no, I'm just briefly referring to this, Your Honor, to simply say that this is a case involving whether what garnishee proceedings refer to and whether debt can be attached. And simply put here, it interprets Order 49, Rule 1 of the Old Rules of Court, where in garnishee proceedings, it provides that the court may order the garnishee to pay the judgment creditor the amount of any debt. So the word debts due or accruing due. And the court had referred to a bunch of cases, an Old English case in 1883, where it defines debt similarly.
So do you have anything stronger, Mr. Kwa?
No, Your Honor, I'm moving on to my next two cases, but this one, I just wanted to make the point here. And the court did say, referring to the Old English case of 1883, as well as at paragraph 16 of the judgment, where the Old English case says that debt is a sum of money. He also cites other English, Indian, and Malaysian cases. And I think that those are relevant. I won't go into detail, but Your Honor will see that essentially it has, in those Indian, English, and Malaysian cases at paragraph 16 of Tan Tiam Hock, that the AR has adopted the English holding in respect
Yes.
of what the debt is.
All right. Anything
Your Honor,
strong?
no, I'll move on, Your Honor, to the Algoran and 3AC case,
Yes.
which Your Honor is at tab 5 of my bundle.
Yes.
And Your Honor, I think I would characterize the case somewhat different from my learned friend, Mr. Liu. If Your Honor looks at page 3 of the notes of evidence of Mr. Justice Kumarasamy,
Yes.
if you see what Mr. Chan says as counsel for the applicant says, what his arguments are in relation to the case, he says that his case, and this is at line 5, he says that his case is that USDC is a form of money that is capable of being the subject matter of a claim in liquidated damages. Then he argues, of course, he fails in his argument, is that a claim for liquidated damages ought to be treated as a claim in debt that is capable of forming the subject matter of a statutory demand. So, Your Honor, you see that he is making a very broad argument in relation to the nature of a claim in cryptocurrency, although he does say that, yes, this is only ultimately specific to a statutory demand, but his arguments are wider than that. Your Honor would be familiar with the conclusion by Justice Kumarasamy that he does not accept that cryptocurrency is money for the court jurisdiction to make a winding up order. And this is at page 69, Your Honor, of the notes of evidence. And in fact, just to be clear exactly what he says, and this is at page 69, line 15, he says very broadly, this is his holding, I do not accept that cryptocurrency is money for the purposes of the court's jurisdiction to make a winding up order. And this is a very broad holding, Your Honor. Or in this context, and he does then specifically state that this is particularly in the context of section 1252A of the IRDA in order to give rise to the presumption of insolvency. But his holding is a very broad holding that relates, and he says here, the court's jurisdiction to make a winding up order, which presumably, Your Honor, includes, which is what we're arguing for today, section 1252C. And he adds, Your Honor, at the bottom, at at line 28 of the same page, he says that the word indebtedness, in my view, must require that it is a debt which is in a fiat currency.
All right.
So, Your Honor, I would also point, Your Honor, just briefly some comments on this decision. At page 6, sorry, Your Honor, if you could move back there.
Sorry, yes, page 6.
Page 6.
Yes.
Where after the counsel had ran through some authorities, at line 9 or line 10, the court asked counsel that, generally speaking, would you accept that a debtor would be someone who owes money by reason of a contractual obligation to pay money or to repay money, or who owes money because an underlying civil cause of action has been merged through a judgment or merged into a judgment and then gives rise to a judgment debt? And counsel says, I would accept that. And Your Honor, that is my argument that I made earlier today, that a claim in damages needs to be crystallized first into a judgment, a judgment before it crystallizes into a judgment debt. And therefore, then it would qualify for a winding up order.
All right.
So the arguments that were made in this decision, Your Honor, there were 4 arguments that were made in the Algorand case by counsel for the applicant, saying that cryptocurrency, in this particular case, USDC, should be a form of money because 1, it is a medium of exchange. But at page 59, Your Honor,
Yes.
the learned judge says that it is not widely accepted as a medium of exchange. In fact, the amicus curiae in the same case says that it is a speculative investment vehicle. And Your Honor, this is echoed by the Monetary Authority of Singapore, where in its consultation papers, which we have exhibited at tab 11 and 12 of our bundle, which echoes what the amicus curiae in the 3AC case says. 2 points. 1 is that cryptocurrency prices are not related to underlying economic fundamentals, and therefore the extreme price fluctuations rule them out as a medium of exchange. So simply put, Your Honor, the learned judge in the 3AC case rejected the argument that USDC is a medium of exchange on the basis that it's not widely accepted. And now we have MAS also coming in to say, in recent consultation papers released, that similarly it is not a medium of exchange. The second argument that the applicant's counsel made in the 3AC case was that cryptocurrency is a store of value and that it's reflected on the public blockchain ledger, which is used to buy goods. And the analogy was raised similar to Mr. Liu, who said that, El Salvador uses cryptocurrency as its national, well, it's accepted as a form of legal tender. And the same argument was made before Justice Kumarasamy that cryptocurrency is analogous to foreign currency. However, the judge said that not everyone accepts crypto. El Salvador is a very small country, and it has been shown in recent times that the decision to allow cryptocurrency to be used as a form of legal tender has affected the economy significantly. And I think Singapore has been very cautious in that regard. Of course, the very famous quote that has been reproduced in various forms is that, in the past, seashells were a form of money at one time in human history, but it is not at this point in time. And simply, in Singapore at least, cryptocurrency is not, at this point in time, accepted across society as a form of money. The third argument made was the society theory, that the applicant's counsel said that cryptocurrency has growing acceptance as a medium of exchange. And there are some US cases which have recognized Bitcoin as a form of money. Although I'd be cautious, Your Honor, because the US cases that have been cited by my learned friend refer to this society theory in a very narrow form, because these cases were only used by the courts to decide whether cryptocurrency was a form of money for the context of specific statutes, especially in the context of money laundering. And I think that there are other policy reasons that would apply in money laundering cases where cryptocurrency has been recognized to be used as a form of illicit money laundering. And therefore, simply for the purposes of saying that Bitcoin is accepted as a medium of exchange for the specific purpose of money laundering statutes, I think there is a good reason for the US courts to say that. However, once again, even in Singapore and in many countries around the world where cryptocurrency exchanges are banned in its entirety, including countries like China, it is difficult to say that there is a wide acceptance in society of cryptocurrency as a medium of exchange.
All right.
The final argument, Your Honor, that was made was citing a case of Dway's International, a 2022 case, where the court had awarded monetary damages in USD upon finding that USDC in a wallet belonged to the claimant. But Justice Kumarasamy said in response to that argument that that is simply a general application of quantification of loss. In fact, he goes on to say that if the claimant in that Dway's International case had framed his claim or framed his case as a case or claim for cryptocurrency, then he says it's a claim for specific performance. It is not a claim. He goes even further to say doesn't say it's a claim in damages, it's a claim in specific performance. It's not in monetary debt. So therefore, there is a difference between debt and liability. One more point for this case, Your Honor, at page 46. My learned friend said that, you have to extend the definition or take a wide definition of liability in the context of the IRDA. However, Justice Kumarasamy says at line 21 of page 46.
All right, sorry, Mr. Clark, I'm a bit wary of taking comments from the court in the midst of arguments that strongly I would only really place weight on the final pronouncement by the court. In the course of arguments, we sometimes raise things, to be honest, just to test reasoning and that sort of thing. So the questions and responses in the course of arguments don't really constitute the finding or judgment of the court.
Yes, Your Honor, and I'll refer to that as, in a sense, obiter dicta.
It's not even obiter dicta. These are just things we raise in the course of argument. Sometimes we float various things. So if you're relying on that, I really wouldn't put any weight on it. I would, as I said, I would look at Justice Kumarasamy's pronouncements at the end of it. The rest of the things, I really wouldn't use it to guide my reasoning or findings.
Yes, Your Honor, and I'm grateful for Your Honor's clarification. And I think I stand by my principal argument that the statute is clear as defining debts as a claim in money, and that liabilities, as defined in statute as well, is a claim in money or money's worth. And so therefore, cryptocurrency being not money, the court's jurisdiction to wind up a company under section 1252C on the basis that it cannot pay its debts as it falls due is not invoked.
All right. Yes.
The last case I will refer to is the case of Bybit, Your Honor. FinTech. This is at tab 7 of my bundle.
All right.
Justice Philip Jeyaretnam's decision, where he holds that a claim, a USDT claim, is a chose in action. Essentially, this is a contractual claim for fraudulent withdrawals of money. And at paragraph 36 of the decision, the conclusion of the learned judge says is that the holder of a crypto asset has in principle an incorporeal right of property recognizable by the common law as a thing in action and so enforceable in court. And he says that, a few lines down, it is only because people generally accept the exchange value of shells or beads or differently printed paper notes that they become currency. Money is accepted by virtue of a collective act of mutual faith. So what he essentially is saying here is that, cryptocurrency to some extent is treated as money, but it is confined to the contractual claims made and for the purposes of quantifying the amount of damages. And if you see the relief sought in this case, Your Honor, it is one where the claimant is seeking both specific performance of a return of the cryptocurrency as well as a fiat, a claim or the equivalent of the cryptocurrency in fiat. And therefore, the court made a decision that as a matter of quantification of loss, that upon the appropriate conversions made, when first only recognizing that a cryptocurrency claim is just a chosen action or incorporeal right of property, that he has to make a decision to decide that these claims should become judgment debts, and therefore he came to that conclusion. So the point, again, Your Honor, is that debts do not include money claims. It's only until a judge or the appropriate court decides that a claim in damages, or even a claim in specific performance, depending on how you frame it, should be quantified as such for the purposes of determining what is the loss to the claimant. Then it becomes a judgment debt.
So, Mr. Kwa, if we are dealing with a wine vault of some sort and something happens to all the wine bottles, they're all destroyed, and all the clients, the only thing the clients have would be, say, trust receipts of some sort, but it's quite clear nothing is left in the vaults, all the wine's gone. We still can't actually say the company is insolvent until the clients actually sue and obtain a judgment for the monetary value of what the trust receipts represent.
Yes, Your Honor, that is my argument.
All right, carry on.
And that shades into my second argument, Your Honor,
Yes.
in relation to the gating.
Mhm.
Because I had alluded to this earlier in relation to gating, is that the terms of use do provide very specifically, and if Your Honor could turn to the terms of use itself, it is in Mr. Zhu Chuntao's first affidavit filed in OA 451.
All right, sorry. Hold on a moment. Let me bring that up. What was the date of the affidavit, please?
12th of August 2022.
12 August. All right, hold on. It was in OA 451 or one of the summonses?
Apologies, Your Honor. I believe it's in OA 451. It's his first affidavit filed in support of the application for judicial management. Dated 12th of August.
2022. All right.
Yes, that's right. And I'm looking at page 165, Your Honor. Specifically, yes.
Well, hold on a moment, please. All right, so 165 would be clauses 15.2 thereabouts. All right.
Yes, that's right. I'm looking specifically at clause 16.
All right.
And so the key point here, Your Honor, is that the way in which the business of Hodlnaut worked, it provides here, in consideration for the use of the service, the user hereby grants the Hodlnaut group the right to hold the digital assets held in the relevant user account. And it's very broad what you can do: to pledge, repledge, hypothecate, rehypothecate, sell, lend, or otherwise transfer or use any amount of such digital assets separately or together with any other property with all attendant rights of ownership.
All right.
So basically, there is no trust created for users. When users put the money or the cryptocurrency into the account, it is pooled together with all the other assets of the other users, and the Hodlnaut group uses those cryptocurrencies to make further investments to generate a return. And in respect of a withdrawal, Your Honor looks at clause 12.
Well,
This is on page 161.
yes, clause 12. All right.
12.1, that the user may make a complete or partial withdrawal of his user digital assets, say for when he puts it in fixed deposit, and the Hodlnaut group then initiates a withdrawal process immediately following a withdrawal request, and will take some time to process the withdrawal.
Right.
At 12.3, Your Honor, this is where the gating provision is provided for, that it says the Hodlnaut group may experience cyber attacks, extreme market conditions, or other operational or technical difficulties which could result in the immediate halt or suspension of deposits and or withdrawals, either permanently or temporarily. And it shall not be responsible for or liable for any such loss occurred when there is a suspension of deposits or withdrawals. And in 12.4, Your Honor, here, it says every withdrawal request shall be deemed pending until accepted by the Hodlnaut group, and may refuse to accept such requests. So contractually, Your Honor, if you look at all these provisions, the users had agreed that their assets will be pooled, invested together, and in such an event that they exercise their right to withdraw, the Hodlnaut group has the right to gate any withdrawal. And in this case, Your Honor, I think it is key to note that since the gating was done, and then subsequently, very shortly after the gating was done by the directors of Hodlnaut, it was put into IGM, and the IGMs took over and were aware of this gating. And throughout the whole case, there has been no affidavit shown where users have actually sought to withdraw any of their deposits. Therefore, such liabilities, if any, have not been crystallized. And in any case, they have agreed contractually not to have such liabilities crystallized for the period of such withdrawal halts.
All right, hold on a moment, please. So which clause would you say says, which clause do you think says that quite expressly?
Clause 10.3.
10.3.
Yes.
Sorry, did you mean 12.3 or 10? Because 10 seems to be 10.1.
Oh, sorry, 12.3, Your Honor. I apologize. Yes. 12.3.
It doesn't say there's no crystallization.
So having gone through the withdrawal requirements before there is a liability that it crystallizes in 12.1, the argument simply is that, well, I mean, there are two layers to this. One is they haven't sought to withdraw their money. And the second is, even if they have, which they haven't, the company is entitled contractually to impose what we call a gating or a withdrawal halt.
All right.
Of course, there is a question as to whether such a withdrawal halt is reasonable or unreasonable, and there could be arguments raised under, for example, UPTA as to whether the clause is reasonable or not. But no such argument has been made. And in fact, my client has in affidavit acknowledged or said that there are reasons for why there are situations where a permanent halt or a temporary halt is necessary. Of course, one is extreme market conditions, which in this case was the case, given the USDC crash and the subsequent bankruptcies of various cryptocurrency firms. But also, Your Honor, when we have fraudulent transactions that are made, stolen cryptocurrencies that are traced to a wrongdoer's blockchain address, or used for other illicit purposes, or even situations where private keys have been compromised. Your Honor, this is covered in my written submissions from paragraph 52.
Yes, so Mr. Kwa, I think if there's a no crystallization clause that's quite expressed, that might be might make your position much stronger, and it will be something that would, I think, give any pause in determining whether or not there's cash flow insolvency.
Yes.
I don't know whether 12.3 or even the rest of the clauses here really add up to that, but could I just confirm with you that there is no provision, no clause in the customer contracts that actually say no crystallization?
Not specifically to that, Your Honor. And I think I've made my points, and I can't go any further than what has been said or interpreted, or how we interpret it in our
All right.
based on the terms of use.
All right. Thank you, Mr. Kwok. Thank you
And
for
just
that.
to close off
Can
that
I
point, Your
just
Honor. Yes.
Can I just talk at this time? How much longer do you require, Mr. Kwok? Just coming up to 12, just roughly. Because
maybe
there's still
about 20 minutes, Your Honor, I believe.
sorry, how many more minutes?
About 20 more minutes, Your Honor. My
All right,
point.
so, hold on. So, Mr. Kang, how long do you estimate?
Your Honor, I estimate that I'll take probably 10 minutes. I'll try to do it shorter.
All right. So, and then my assumption is that no one else needs to chime in substantively, but I'll take stock later. Mr. Liu, currently, what's your rebuttal going to be like?
Your Honor, I should be able to complete my rebuttal in 20 minutes.
All right, thereabouts. So we'll go slightly beyond 1 if need be. All right, thank you. All right, carry on, Mr. Kwok.
Yes, Your Honor. So just to round up my second point on gating,
Yes.
I think the facts do show that there are sufficient cash assets in the company to make payment of the cash liabilities, which are for office expenses and other miscellaneous expenses. So therefore, when the cryptocurrency,
the amount in start terms, so how much cash liabilities, how much cash assets from your point of view?
give me a moment, Your Honor. We have this in our.
Yes.
Paragraph 28 of Mr. Simon Lee's first affidavit in CWU, that's the 30th of June, Your Honor.
Oh my God. In the CWU. All right. Oh, that's right.
Yes, Your Honor. In fact, paragraph 34 is the one that is more specific.
All right. Hold on a moment, please. So which paragraph?
Paragraph 34 of Mr. Simon Lee's first affidavit dated 30th of June 2023. It says, it reads, the only debts that Hodlnaut SG owes its creditors in fiat. Does Your Honor see that?
Hold on a moment, please. Yes, 273, etc., right? Paragraph 34.
Yes,
All
that's right. So that's our position.
All right. So 3 mil cash in the bank, that will more than cover all these debts. All right, thank you.
Yes. The third argument that I make, Your Honor, is in relation to the restructuring. Just a brief point. Mr. Liu has mentioned that there are ongoing discussions, and I believe where the discussions with OpenX, Mr. Mark Lam had left off was that they were invited, or he was invited to come back with a revised proposal, and vice versa as well from the IJM, saying that there are concerns that have been raised by the creditors relating to whether there's any cash backstop. And I think that the parties have left the last meeting to discuss that. So I don't believe it's closed, although I do understand that the IJMs have taken a position as to the viability of any such restructuring. But I leave it to Your Honor's hands as to whether Your Honor should exercise its discretion in light of the still ongoing restructuring, as to whether it should be adjourning the winding up.
All right, but your position would be that my discretion should be exercised in favor of adjournment, correct?
Yes, Your Honor.
All right, carry on.
The final point, Your Honor, is in relation to the appointment of EY, of the two IGMs as liquidators. Just at the outset, Your Honor, I would like to say that we have identified 3 alternative liquidators who have provided to us written consent to act as alternative liquidators if the court is minded to appoint someone other than EY. And sorry, Your Honor.
Yes, carry on, please. Yeah.
And the argument that we be making, Your Honor, in relation to the appointment of the IJMs as liquidators of the company is, to use a phrase colloquially, they won't be able to own self, check own self.
All right, so your issue of conflict, would you like to specify what that is then?
Your Honor, it's not so much an issue of conflict, but an issue of, and with greatest respect that I say this, in relation to the competency of EY and the team in relation to cryptocurrency matters. Your Honor, we have 3 points to be made, and we have fleshed this out very detailed in my client's 8th affidavit in full as to the reasons why there may be a situation where the IJMs may not investigate into certain actions that they had taken while they were IJMs if they were appointed as liquidators.
Right.
The first incident, Your Honor, is what we call the FTX saga. Your Honor had heard arguments on this in previous applications, although that was in the context of seeking a discharge of the IJMs. In this case, Your Honor, all I'd be seeking to say is that warnings had been given prior to the collapse of FTX by the directors since as early as 29th of August 2022 to transfer assets on centralized exchanges to third-party custodian or hardware wallets. So 29th August 2022, the first warnings were given by the directors that, look, if you are taking over this, that's fine. Please make sure you secure the crypto assets of the company. And I mean, it's clear that the IGMs have their own cryptocurrency wallet. This was identified at paragraph 53 of my client's 8th affidavit, that they do have a cryptocurrency co-wallet. So they could have transferred these assets on centralized exchanges to their own co-wallet to preserve them. However, it was only 2.5 months after the warnings were given, on the 9th of November 2022, that the IGM's team had lodged support tickets with FTX. And so that's 2.5 months since the first warnings were given. And the details as to all the warnings and all the signs in the public crypto sphere are stated in my client's 8th affidavit. So the proof of debt in relation to FTX was approximately USD $13.3 million. So that's a fairly significant quantum, $13.3 million US worth of cryptocurrency. The second point, Your Honor, is the disposal hearing that was heard in relation to the funds, or US $10 million that was frozen by the CAD of the company's funds. So, Your Honor, we had gone through the terms of use earlier, in particular the clause which provided that all deposits of users are aggregated and then invested into DeFi protocols and other investments. So arguments were made in respect of the disposal hearing, basically opposing each other. The IGM saying that the money should be paid back to the company, and Samtrade, which is one of the creditors, arguing that a constructive trust had resulted, and therefore the funds should belong to them. The IGMs were unsuccessful in resisting the Samtrade's arguments, and so the monies were then released by the CAD to Samtrade. The third point, and this is where I do have to go through in a little bit of detail, Your Honor, is if Your Honor looks at my client's 8th affidavit, and this is what we relate or we refer to as the flex transactions for which the IGMs were unable to deal with.
Right.
Right. At paragraph 55, I start with that, Your Honor, of my client's 8th affidavit.
Yes.
Is Your Honor there?
Paragraph 55, was it?
Yes.
All right. Yes.
So what happened at the start was, this was 6 September 22, when the IGMs came to place, the directors had said, look, how do we deal with the assets of the underlying company, Hodlnaut Hong Kong, given that they were the bulk of the group's assets? In fact, what had happened was there was an Ethereum fork that was going to happen later that month. So at paragraph 57, Mr. Zhu said that his advice was for the company or the Hodlnaut Hong Kong to return the assets to the company so that the IGMs can have custody of it. In fact, he said that we would like to hand over the private keys to the IGMs so that the IGMs can take control over the entire group, so that there's no allegations of impropriety on the directors' conduct, because everything would be held by the IGMs. Instead, they said that they had to consider legal ramifications, and paragraph 59, this is lifting from the email exchange. The IGMs advised that they have no legal standing or authority to provide the directors with instructions on what to do with the Hong Kong assets. Instead, they said that the directors are responsible for discharging their fiduciary duties by taking all necessary steps to protect and preserve the value of Hodlnaut Hong Kong's assets. And paragraph 60, again, it says that we maintain the status quo, but as directors of Hodlnaut Hong Kong, you are responsible for making the decision relating to the merge. If you take the view that a different course of action would be in the best interest of Hodlnaut Hong Kong, you should do so. And they said in paragraph 61, they do not take any responsibility for the ultimate decision that Hodlnaut Hong Kong takes on the merge. So at paragraph 64, Your Honor, similarly on another example of what happened with Hodlnaut Hong Kong, so that they invited the directors to unwind certain DeFi positions and deposit it into a co-wallet. And at paragraph 65, Mr. Zhu had said, sure, we'd be happy to do that, to ensure that the handover of assets is done in an expedient fashion, and to ensure that there is no preferential treatment given to the creditors of Hodlnaut Singapore. Then it should be properly ring-fenced. So he had asked for a letter of indemnity, or in fact, at paragraph 66, Your Honor will see that they had invited the IGMs to replace them as directors of Hodlnaut Hong Kong, so that there'll be no aspersions that will be cast on their conduct if they were to do or take steps to manage Hodlnaut Hong Kong based on what they thought was in the best interest of the company. And then basically the conclusion there, Your Honor, was that we won't give you the letter of indemnity, you just act in accordance with what you think is best. And in fact, at paragraph 70, Your Honor will see that the IGMs then issued a statutory demand against Hodlnaut Hong Kong.
All right.
So, Your Honor, what had happened subsequently, and this was canvassed before Your Honor at earlier hearings, giving the suggestion that Mr. Zhu and Mr. Lee had been dealing with the assets of Hodlnaut Singapore. That's not correct. What has been said here is that, look, we have these assets belonging to Hodlnaut Hong Kong. You've asked us to deal with the assets as we think is best to preserve value of the assets. Given that this is a cryptocurrency environment where it's very volatile, that hackings that happen on a regular basis, and things need to be done to ensure that the assets are held for the creditors of Hodlnaut Hong Kong. And so what happened was that the directors had entered into transactions, the Flex and Razor transactions. And what had happened thereafter was that there has been, for over 3 months, information on the public sphere relating to the conversion of Flex to Ox, because Flex tokens were going to become defunct, and Ox was the new token that would be used by OpenX. And the directors, Mr. Lee and Mr. Zhu, were unable to ensure that the company, or Hodlnaut Hong Kong, was able to convert its existing Flex tokens to Ox, because there were restrictions placed by the IJMs on Hodlnaut Hong Kong by the insertion, or the appointment rather, of 3 additional directors, as well as a special resolution providing for transactions above a certain amount to be, where consent was required to be obtained before that could be done.
Well, the upshot, Mr. Kwa, is that you see all of this points to the unsuitability of the present IGMs to function as liquidators.
Correct, that's right, Your Honor. And I think if Your Honor just looks at paragraph 85 and 86 of the affidavit, it would set out in detail what the directors believe would be the loss that would be suffered by Hodlnaut Hong Kong as a result of the actions taken or the inaction by the IJMs. And so, Your Honor, the conclusion is simply that not so much that there is a conflict per se, but I think there are sufficient points that have been raised where the conduct of the IGMs in their carrying out of their duties as IGMs, that there are certain transactions of which are fairly significant. One is 13.3 million USD, one is 10 million USD, and the Flex deal potentially is worth over 100 million USD. So these are fairly significant transactions for which, I think, to be safe, we would propose that alternative liquidators be appointed.
Could you bring me to the affidavit where the 3 liquidators are named, please? That was
Your Honor, we don't have at this point in time on affidavit the 3 alternative liquidators, but if Your Honor wishes,
file there in the room, please. Thanks.
sorry, Your Honor,
File a supplementary affidavit, please.
I will, Your Honor.
All right. Could you do so by today's the Monday, by Friday?
Yes, Your Honor.
All right. Anything else, Mr. Kwa?
No, Your Honor.
All right. Thank you so much. All right.
Thank you.
So, all right. So, together with their consent, please. Thanks. All right. All right. Thank you, Mr. Kang.
Yes, Your Honor. Your Honor, with your indulgence, I'll just highlight a few matters. I'll be very brief and try to keep it within 10 minutes. I'll deal in the main, Your Honor, with CWU 94 with regard to the interpretation on the word debt and liability, and then I will close off with some very brief submissions on Your Honor's discretion in ordering and winding up. Your Honor, I did not file fresh submissions. I filed an earlier set of submissions on the 31st of July. I've also tendered a set to Your Honor. May I just inquire if Your Honor has them?
Yes, I have the submissions. Thank you.
Yes, Your Honor. I don't propose to go through my submissions per se, but perhaps in the course of making my submissions, I will just flag out a few paragraphs to assist Your Honor in terms of the referencing. Your Honor, our overarching position is that cryptocurrency is not a money in debt for the purposes of winding up. I move first to deal with the interpretation of the word debt, Your Honor, in section 125 bracket 2 bracket C, Your Honor. Your Honor, Mr. Kwa referred to the case of Algerian and 3 Arrows Capital. I do not propose to go through in much detail, safe to say that in that case, the court was of the view that the word indebtedness in section 125(2)(a) of the order must require a debt which is required in fiat currency, Your Honor. This is at paragraph 6 and 7 of my written submissions. Furthermore, the court was not able to accept that an obligation to deliver cryptocurrency, even if it's a stable coin, is an indebtedness. In my respectful submission, Your Honor, the definition of indebted debts and indebted in section 1252A assists in the interpretation of the word debts in 1252C. And this is found at paragraphs 12, 13, and 14 of my written submissions. In essence, where identical expression is used, it should be presumptively have the same meaning. I will also make reference, Your Honor, to the case of international placements, where the Honorable Justice Hu Xiaoping, she cited the Court of Appeal case of YCH District Park. This is at paragraph 17 of my submissions, Your Honor. Essentially, the point is that when ascertaining possible interpretations of text, the court will endeavor to give due consideration to other legislative provisions. Here, I turn to, Your Honor, section 153, subsection 1 of the ERDA. This is found in my bundle of authorities. Essentially, it is in relation to the stipulation for payment of debts, and the reference is to money due from the contributory or estate of the person. I also refer, Your Honor, to section 203, subsection 1, which relates to the priority of debts. Different payments, different debts are set out there, and they relate to payments in the form of money. Finally, Your Honor, there is also the proof of debt form. I've set out the entire form in my submissions at paragraph 21, Your Honor. And again, the debt is with reference to fiat currency. Finally, also the MAS views as the regulator. The excerpt of the relevant portion, I've also set that out at paragraph 25 of my submissions. Essentially, taking these things in the round, Your Honor, is my respectful submission that a obligation to deliver currency is not a debt in money. I turn now, Your Honor, to deal with the meaning of the word liability.
Yes.
Yes, Your Honor. Liability essentially has to be in money or money's worth. Your Honor gave an example of wine, and Mr. Liu, apples. Given my personal preference for wine, I'll use the wine example, and I'll try to address Your Honor's queries with regard to that. When a company, whether it holds wine or apples, that's an asset. I don't think that's disputed. Whether it's a current or non-current asset, it really depends on the financial treatment. Mr. Liu made a point that it is absurd if it's considered a current asset but not a liability. I will respectfully disagree. Liabilities are liabilities in money's worth. I pause there and I invite Your Honor to pick up my bundle of authorities. Essentially, I'm referring to Sun Electric.
Yes, Sun Electric.
Yes, Your Honor. Sun Electric is at tab 4 of my bundle of authorities.
Yes.
If I may invite Your Honor to turn to paragraph 66 and 67, in particular 67, which Mr. Liu also referred to.
Yes.
Your Honor will see at paragraph 67 where the Court of Appeal discusses what the current assets and liabilities may be and what present debts and assets may be. At the 4th line of the paragraph, there is a reference to a debt of 10,000 today, but may be due, but the company may be due to receive an incoming payment of 1 million tomorrow. Further down the paragraph, the judgment reads, conversely, a company may have 10,000 in hand today and no debts due today. My simple point is that liabilities are expressed in monies. Prospective liabilities, commonly they refer to loans that may be maturing. These are booked in as liabilities. Contingent liabilities may be where there is a pending lawsuit and the accountant is able to crystallize perhaps what may be the damages. An obligation to deliver, whether is it cryptocurrency, wine, or apples, in my respectful submission, that they don't book those in as liabilities. In the situation where, say, a customer invested in wines and those wines are supposed to be held in my storage and I do not have those wines anymore, in my respectful submission, it's not for the customer to then apply for and winding up on the basis that I do not have the wines in storage, because I may have cash to pay if the customer makes a demand, and that is on the assumption that I accept that I'm in breach.
Yes, but my difficulty with this situation, Mr. Kang, is really that if I look at the position as a whole for the entire company here, can it really be said that the company is not balanced, it's not cash flow insolvent? If you look at it as a whole, so we're not looking here at a situation where a creditor or investor is filing a specific claim of non-payment and that sort of thing, but we're looking at a situation where the IGMs who have been in control of the company for about a year, say, looking at it as a whole, we think it's cash flow insolvent.
Yes, Your Honor, I appreciate your Honor's concerns, and we have two of the large creditors here, and they have expressed their views. In my respectful submission, Your Honor, the way the process works is still that they will have to institute proceedings, get a money judgment, and apply to wind the company up. That's just
that might be the case in relation to proof of debt and something, but you're basically saying that, are you saying that we don't look at the position holistically right now?
No, Your Honor, no. I think taking it holistically, Your Honor, there are other issues in play. So there is also the question of the construction of clauses 12.1, 12.2, 12.3, and
Yes,
12.
but that to me is a separate matter. But the thing is, when I look at it as a whole, do I not actually? Well, basically the question is, don't I look at it as a whole when I apply Sun Electric? I'm not looking at a specific claim by individuals. I'm looking at it as a question of the cash flow position, and sometimes the evidence for this may come from aggregating individual claims, but sometimes it's a question of looking at the state of the accounts, seeing what the trading is like, and actually, if the evidence points to there being cash flow insolvency, do I need to really worry whether an individual is able to file a liquidated claim and have it adjudged and have a merger of his claim in the judgment?
I completely understand your Honor's concerns. I won't push the point any further, safe to say that, for instance, if there is a major creditor who wants to withdraw its funds, I think that before it crystallizes into a debt, there still is some dispute of whether or not he or it is entitled to withdraw the funds at this juncture, considering the terms of use.
All right, so you're going to go on to the gating issues. All right, please proceed. Yes,
Your Honor. The short point that I make on the gating issues is those clauses, the construction of it is something to be determined. If the court finds that the company is entitled to gate, meaning the creditor or the customer can't withdraw the funds, then there is no debt, Your Honor. So that essentially, that's something that is to be determined. Your Honor was querying Mr. Kwan whether or not there's any express language on the crystallization of liabilities. I was looking through it. I do not think there is, but there is also clause 12.4, which reads, every withdrawal request shall be deemed pending until accepted by the Hodlnaut group. That, in my respectful submission, would mean that even if a withdrawal request is made, I can refuse to accept it. And again, I don't have any obligation to deliver. I can accept whether that is a reasonable position or not, whether that's a reasonable interpretation. That's in the air, and that's something to be argued on another day, Your Honor.
All right.
Yes, Your Honor. Before I move off to Your Honor's discretion, I will just make one very simple point. This is in relation to what Mr. Liu raised in that the directors had the company file this application in essence to say that the company was insolvent. My clients explained the thinking behind the application, and this is found in Mr. Zhu Juntao's first affidavit in CWU 94, filed on 30th June. At paragraphs 30. Just a moment, Your Honor. at paragraph 11 onwards, the judicial management application.
So his first affidavit, all right, yes.
Yes,
Sorry.
in CWU 94, Your Honor. So in essence, what prompted the thinking at that time? CAD served a seizure order. This concerns the assets balance in the account of Samtrade custodian.
Right.
Subsequently, the company transferred about 10 million worth of cryptocurrency. However, the CAD ordered the group to transfer all the assets. So there was a concern that such a transfer would cripple the group and cause insolvency. At the same time, non-compliance might attract criminal sanctions. So at the same time, or slightly a few days before, there was a JR application, Your Honor. So this really was the thinking. If they were to transfer all the assets out, then obviously they can't carry on business. So I just wanted to flag that up.
What is the point you wish to make out of this, Mr. Kang?
Earlier, I think Mr. Leo made a submission that my clients, the director and the directors accept that the company was insolvent, therefore they filed for judicial management. So I was just trying to address that point in that there was some other thinking behind the filing of the application. It's not insolvency per se, Your Honor.
All right, thank you. All right, carry on, please.
Moving to the last point, Your Honor, which is Your Honor's discretion. All I'll say is this, Your Honor, the directors, my client and Mr. Kwa's clients, they are committed and they firmly believe that rehabilitation is the best option in terms of time and cost savings compared to liquidation. As evidence of their firm commitment and belief, Drew has now entered the fray, Drew and Napier, to advise on the restructuring. Drew is instructed by Housen LLP, which is a Hong Kong law firm representing the directors on matters in relation to Hodlnaut Hong Kong. The OPNX deal is the only offer on the table, and there are ongoing discussions. I do not hear the IGMs to be saying that they are closed off to further discussions. I do not hear that. I only hear them saying as the creditors do not support, so that should be the end of it. The directors firmly believe that the OPNX offer is a good option, and the investments in Flex and Razor will pay off given some time. This, I just move very quickly to deal with the issue of bona fides of their conduct, Your Honor. As early as February 2023, the directors have already indicated on affidavit that they are reaching out to investors. This is set out in Mr. Simon Lee's 6th affidavit filed in OA 451, Your Honor. At paragraphs 32, 46, and 47. With regard to the investments in Flex and Razor, the directors took legal advice from Housen, their legal counsel in Hong Kong, before making these investments. As far as I'm aware, agreements are drawn up. I've not seen them, but I understand that they have been given to the nominee directors in Hong Kong, the nominee directors appointed by the IGMs. I do not advise on these transactions, but I believe the agreements will show the dates, the details, so on and so forth. And there was no attempt to mislead or to go behind anyone.
All right.
So that is just to address the bona fides. And with that, I have nothing else to add, Your Honor, and I'm grateful for your honest patience and time.
All right, thank you, Mr. Kang. All right, back to you, Mr. Liu. Sorry, before that, anyone else wishes to make submissions? Can I confirm?
Yes, Your Honor.
Mr. Ang, all right, yes.
Your Honor, on behalf of Samtrade Custodian and FinTech, just a few short points, Your Honor. First point in relation to clause 12.3 of the terms of use. I just want to highlight the fact that at the relevant time when the halt took place in August 2022, Hodlnaut did not rely on clause 12.3 or highlight clause 12.3 in the announcement to creditors on the halt. Your Honor, this is found in the first affidavit of Aaron Low in the winding up application.
All right. Yes. Anything else, Mr. Ang?
Yeah, I'll move on to the second point. Second point, Your Honor, it's not correct to say that there were no withdrawal requests made by creditors. In the first affidavit of Chan Keng Tek in OA 451, pages 51 and 53, there are two separate letters written to Hodlnaut to request and demand for withdrawal. So it's not correct, my learned friend's point that there were no withdrawal requests made. Finally, Your Honor, I just want to make three short points as to why my clients are of the view that the proposed restructuring is not credible or acceptable to my clients. Three short points. The rest are highlighted in the affidavits already filed. First short point, Your Honor, is the concern in relation to the flex transaction in Hodlnaut Hong Kong and the OPNX term sheet. Your Honor, there's apparently at least 20 million US worth of assets of Hodlnaut Hong Kong, which was invested into OPNX through flex during the period March to June 2022. So there is a concern, Your Honor, which was also highlighted by the IJMs in their affidavit, that this could amount to round-tripping of Hodlnaut assets into OPNX and then back into Hodlnaut Singapore, purportedly for an investment and restructuring. So that's the first concern that my clients have. Second concern that our clients have, Your Honor, is that the OPNX term sheet proposes investments into crypto in the form of flex, and their credibility is now hit when they now say that flex is defunct, when they earlier promised high returns coming from investment in flex. Now they're moving us to OX. I think the IGMs have given their view that this cryptocurrency market is one that's illiquid, thinly traded in relation to flex and OX, right? And therefore is questionable to what extent, right, there will be future prospects. Our client's concern, in fact, is that we may be back in this same position, but much worse off down the road. And the third and final point, Your Honor, is that the OPNX term sheet refers to a potential recovery of 30% to the creditors in relation to the scheme. The IJMs in their affidavit, Mr. Aaron Lowe's first affidavit in winding up at paragraph 20, estimates company liquidation recovery at 22% and the group liquidation recovery at 29%. Your Honor, 30% is therefore too close to be acceptable to our clients, and then we are of the view, likewise, other creditors. And the only comfort given in relation to what if 30% is not hit is that OPNX, a Seychelles company, says they will then undertake to inject more crypto assets to meet the 30% recovery. But the point is that if you cannot meet the 30% recovery, it is unlikely that any investor, let alone OPNX, would be able to or would make commercial sense to inject more assets. So I thought I'd just highlight these few points.
All right, thank you.
Thank you.
All right, I will come to both Mr. Lee and Mr. Chu briefly later, but
Your Honor, apologies, Your Honor. If I may make a couple of points.
yes. So hold on a moment. Let me just take stock for a moment. So don't worry. Sorry, Mr. Chan. Sorry. I was trying to do it in sequence. Hold on. What else is here? All right, sorry. All right, Mr. Chan, what do you wish to say?
Just a couple of points. I seek your Honor's indulgence.
Yes.
The first is to address the case of Algorand, for which I was counsel, and I have a couple of points which I would like to make on behalf of my client.
All right.
First is this. Section 1252A and 1252C are disjunctive sections. An applicant for winding up needs to rely on one or the other, not both. And the word indebted only comes up in section 1252A. In 1252A, the word indebted, I would say, Your Honor, refers to a sum which is fixed or liquidated. In value or quantum, it has to be more than 15,000, and it has to be due immediately. That is in contrast to 1252C, where contingent or prospective liabilities can be taken into account. And Your Honor, if one were to look at the definition of liability in Section 2, it includes present or future, certain or contingent, or amounts which are fixed or not fixed, but can be ascertained as a matter of opinion. So clearly, it's quite the opposite from the meaning of an indebtedness in 1252A. Right. Further to that, a liability can arise under 4 subsections, including contract, tort or bailment, a breach of trust, or an obligation to make restitution. So I think where my learned friends err is that the liability does not mean that the subject matter of the claim itself has to be money. The subject matter of the claim can be something else, but if it can be ascertained what sum is owed as a matter of opinion or by fixed rules, whether such liability arises under contract, tort, or else, or under any other written law provided for in Section 2, that would still be a liability. And that brings me to the next point, which is the suggestion that the word debt has the same meaning throughout the IRDA. Your Honor, I'm afraid I don't quite agree. And the reason is as follows. In 1252A, the indebtedness refers to the word creditor as well. And in 1241, which deals with the standing for an applicant for winding up, a creditor under 1241C can include a creditor of a contingent or prospective debt, or perhaps I should say any creditor includes a contingent or prospective creditor. And what the court in Algorand Foundation and Three Arrows found was that the meaning of creditor in 1241C, following the case of North Bucks, refers to a creditor which has a provable debt in winding up. Your Honor, a provable debt in winding up is defined in Section 2182 of the IRDA, and I won't trouble Your Honor to refer to it, but I would just say a couple of points. First, it includes any debt or liability which the company is subject or may become subject to. In other words, contingent and prospective. It also includes demands for unliquidated damages, as long as they arise by reason of a contract, a promise, a breach of trust, or tort, and a few other requirements which are not material here. So just a demand, Your Honor, would be sufficient. The fourth point is that in 2184, the liquidator or the judicial manager can make an estimate of the value of the debt. So taking these in the round and coming back to the definition of a creditor in 1241C, it's clearly wrong to say that only a creditor with a judgment debt can bring a winding up application. Because by the very definition, a creditor which is only contingent or prospective does not have a judgment in hand. And I would submit, Your Honor, that ties in with 1252C, where a creditor which can prove to the satisfaction of the court that the company is unable to pay its debts, including contingent and prospective liabilities, would nevertheless be entitled to a winding up. All right. Yeah. Next point, very briefly, Your Honor, is on the restructuring.
Yes.
And I think on the restructuring, my client's position has been unequivocal from the start.
Yes.
We oppose the restructuring. In fact, Your Honor, I'll go as far as to say that there is actually no restructuring. There's no pending restructuring. All there is a proposal that has been put forward and rejected by the major creditors. So I struggle to see why this winding up application should be put off pending this non-existence restructuring. Moreover, Your Honor, two issues which stick out from my client's perspective.
Yes.
The first is a fundamental lack of credibility with the supposed white knight. One of the co-founders as we speak, is in prison. Mr. Su too. The other, Mr. Carl Davis, is a fugitive from justice. His whereabouts are currently unknown. As Your Honor would have heard, Algorand is also a creditor of Three Arrows Capital. And at this point, my client's instructions are that they have zero appetite for dealing with the same people who have caused significant losses to them.
All right.
The second and final point, why the restructuring is not acceptable, is because, put simply, we don't want the flex or OX tokens. Those, in our view, are nothing more than a speculative investment. It's not realizable into something that is of value to my client.
All right. All right.
Thank you, Your Honor.
Right, thank you. All right, before I turn to Mr. Leo, Mr. Kwa, Mr. Kang, I'll let you have an opportunity to respond to Mr. Ang and Mr. Chan. Anything else? Mr. Kwa?
Just one point, Your Honor, in relation to the filing by Semtrade of their withdrawal. I think that there is a dispute as to whether Semtrade are creditors of Hodlnaut Singapore, and the position that has been taken in writing with exchange of correspondence between Semtrade and the company is that there is no, and between my client and Semtrade is that we do not accept that Semtrade is a creditor of Hodlnaut Singapore, and therefore there is a question as to whether their withdrawal from Hodlnaut Singapore is a valid one.
All right.
Other than that, I have no further points on it.
Thank you. Mr. Kang?
I have nothing to add, Your Honor.
All right, thank you. Mr. Leo?
Thank you, Your Honor. I appreciate it's 12:45. I'll try to end within the 20 minutes that I estimated, Your Honor.
Yes.
Your Honor, I will deal with some points in rebuttal. My first rebuttal point in some way dovetails with what my learned friend Mr. Chan has already said. And it is regarding the point that my learned friends have phrased that a liability to repay cryptocurrency only really becomes a liability when it's the quantum of the liability is ascertained by a judgment debt. Your Honor, that contradicts on its face the definition of liability in Section 2. And in particular, Your Honor, my learned friend Mr. Chan had mentioned, liability is defined, Your Honor, as including a liability to pay money or money's worth that is capable of being ascertained by fixed rules or as a matter of opinion. Your Honor, the word capable means that it doesn't yet have to be determined. It is something that can be determined by fixed rules or matter of opinion. In the case of cryptocurrencies such as Bitcoin and Ethereum, in fact, the value is readily ascertainable because these things can be purchased online, it can be purchased on the market. So the value is there, it's ascertainable, or rather it is capable of being ascertained. And Your Honor, I just wanted to add that 218 of the IRDA, in fact, fortifies the point that, Your Honor, ultimately, this court, in determining whether Hodlnaut is cash flow insolvent, can make a determination that is holistic and can make a determination as to the debts of, even if, I'm sorry, Your Honor, what I meant to say is that at the first instance, I agree with Your Honor's question that when Your Honor is looking at the issue of cash flow insolvency, based on the Sun Electric test, Your Honor should look at it holistically, especially when Your Honor has two interim judicial management reports that is based on supporting documents such as the statement of affairs prepared by the directors themselves, as well as the underlying accounts that show that this company essentially cannot continue in business. The Your Honor can take that holistic view. But even if Your Honor wants to look at individual debt, say Semtrade's debt or Algorand's debt, firstly, Your Honor, I should point out that apart from the issue of the alleged withdrawal hoard, there is no dispute from any party that these liabilities are due. It's not a matter of, oh, actually there may be some defenses as to why we don't have to pay this to the customers. The only defense is, oh, there's a withdrawal halt. So if that is overcome, Your Honor, these are essentially undisputed liabilities. And Your Honor, I wanted to just draw Your Honor's attention to 2184 and 7 of the IRDA. Because, Your Honor, if I may read, 2184 says, an estimate is to be made by the judicial manager or liquidator of the value of any debt or liability provable under this section that by reason of its being subject to any contingency or contingencies or for any other reason does not bear a certain value. So when it comes to insolvency, debts provable insolvency, the judicial manager or liquidator is empowered to make an assessment and estimate of the value of the debt. And 2187, Your Honor, the court has that same power. If in the opinion of the court, the value of the debt or liability can be fairly estimated, the court may assess the value of the debt or liability and may give all necessary directions for the purpose of valuing the debt or liability. And the amount of the value when assessed is deemed to be a debt provable in the judicial management or winding up of the company. So there are many sections in the IRDA, Your Honor, which contradict this notion that a debt has to be one that is pronounced by the court. And even as a matter of legal theory, Your Honor, I think it's incorrect to say that liability only arises upon the judgment of a court fixing the quantum. What the court is doing in delivering its judgment is pronouncing what the position is. The liability already exists. And if the liability didn't exist, then there's nothing to commence. So, Your Honor, I think just even as a matter of legal theory, it's not correct that at the end of the day, when the judgment comes out, then the liability arises. That's not correct. And, Your Honor, I would just add that in the Sun Electric case, and I don't need to turn Your Honor to the case, the Court of Appeal actually said a debt does not even require the debt to be already due or demanded. So the Court of Appeal is saying that when it is taking this commercial view of insolvency, a debt does not even have to be demanded, much less due. So, Your Honor, again, this contradicts what my learned friends are saying about how Your Honor should look at the issue of cash flow insolvency. I then turn to the clauses on the withdrawal halt, Your Honor. And if I could, for this, Your Honor, if Your Honor doesn't mind, if I can turn Your Honor back to the same bundle my learned friend had referred you to, that would be the bundle of documents of the IGMs dated 31st July 2023. It's a red spine bundle. This is volume 1 of 4.
Hold on a moment, please.
Yes, Your Honor.
Volume 1.
Yes, Your Honor, 1 of 4.
All right, yes.
And if I can turn Your Honor first to tab 7. And if Your Honor has tab 7.
Yes.
Your Honor will see that tab 7 is the first affidavit of Zhu Jintao dated 12 August 2022. That is Mr. Kang's client. I just wanted to show Your Honor first paragraph 16. That's at page 456 of the bundle.
Sorry, what page again?
456 of the bundle, page.
Of the bundle, all right, thank you.
Yes, paragraph 16.
Yes.
Your Honor will see that this is Mr. Zhu's own position as to how the business of Hodlnaut worked. He says, any tokens deposited by the Hodlnaut Group's users will be recorded as a liability owed to the said user together with interest accruing on such tokens. Your Honor, this is repeated at paragraph 22, 5 lines from the top of paragraph 22, where Mr. Zhu says again, this is because the Hodlnaut Group instead owes liabilities to its users when users deposit tokens. Your Honor, 2 points from this. First, Mr. Tsu's own position is that when the users deposit tokens, and he's not saying at the withdrawal stage, when they deposit tokens, what will happen is that those tokens form part of the assets of the Hodlnaut group, but in return, it's recorded as a liability. So it's not that the liability only accrues later on where there's a withdrawal request. The liability is recorded straight away. And he tellingly uses the word liabilities. But now when it comes to a winding up, suddenly liabilities doesn't mean the same thing. But Your Honor, if I can show Your Honor again 12.3, which is at page 611 of the bundle.
Could you give me the page of the affidavit, please?
I'm sorry, Your Honor.
That's all right, that's all right. I'm using...
Your Honor, it's an exhibit, so there's no affidavit page. I'm sorry.
All right, thank you. Never mind. Lost 12. All right, Kara?
Yes, Your Honor. So this is paragraph 12 of the terms of use withdrawals that my learned friend had brought Your Honor through earlier. I think as Your Honor had questioned, I think both my learned friends had confirmed there's no clause saying that liabilities don't accrue. I was just going to say that if Your Honor looks at 12.1, it's actually quite the opposite. If I could refer to 5 lines from the top, the Hodlnaut group initiates the withdrawal process immediately following a withdrawal request. And again, that's why I say it's a process or procedure that is being done. So when you institute a withdrawal request, you start the process from which you get paid back. But as Mr. Tsu had said earlier in his affidavit, the liability is recorded right at the outset when they deposit the cryptocurrency token. And Your Honor, 12.3 is important because it fortifies my submission that this clause is not meant to operate when the company is in liquidation. It is or in interim judicial management. It is a business as usual clause because, Your Honor, it says the Hodlnaut group and its third-party partners may experience cyber attacks, extreme market conditions, or other operational or technical difficulties, which could result in the immediate halt or suspension of deposits or withdrawals. So what they're talking about is issues that arise in the ordinary course of business where the company is operating. Where it is in IJM, these clauses on their face don't apply because the company is no longer business as usual. So, Your Honor, my submission is that Your Honor had rightly questioned my learned friends as to whether there's any clause that said there is that the crystallization of liabilities only happens when a withdrawal request is made, and they confirm it is not so. Mr. Tsu himself, in his affidavit, suggests it is not so, and the plain words of the clause again suggest it is not so. Your Honor, I then now want to come to, if I might just very briefly on the case of Bybit. I don't intend to belabor the point, but I think my learned friend's submissions on this case are taken out of context. And in particular, Your Honor, Bybit was concerned not so much with the liability to repay cryptocurrency, but the nature of cryptocurrency that is owned, and in particular, whether it can be held on trust. So far from being against my case, Your Honor, Bybit actually supports my case because in Bybit, Your Honor, the learned judge found that cryptocurrency is property in the sense that it can be held on trust. It is a chose in action. But the focus in that case was on what is the nature of cryptocurrency that I own. The chose in action language talks about my chose against the issuer of the cryptocurrency. It is not that if I'm owed cryptocurrency, that liability only arises upon getting judgment. That's simply wrong and not what the judge was saying. Your Honor, then I want to come to the point about the restructuring, Your Honor. So I'm moving to the last 2 points and I'm trying to be quick. Your Honor, I think at the outset, I need to say that with the greatest respect, I don't think Mr. Kwa has correctly characterized the state of the discussions between the IGMs and OPNX and the directors. Your Honor, we have set it out in quite a lot of detail in the 8th affidavit of Mr. Aaron Low. Your Honor, this is a case where after Your Honor gave directions for CWU 94 to be adjourned so that the IGMs could consider the OPNX offer and discuss this with creditors, Your Honor, we took pains to do so. We did not form any preconceived notions. We immediately sought a meeting with OPNX and the directors. OPNX didn't agree to that meeting. We then set out an extensive list of questions for OPNX, in particular, raising all the issues that remain today, such as creditors don't want your flex tokens. Are you ready to put in capital in the form of cash or stable coins? That was repeated more than once. We asked them the question. The response was always, our terms are as stated in the OPNX term sheet. We asked for financials to assess the creditworthiness of OPNX to see, could they even do this deal? Or is it just a dilatory tactic? We still don't have those supporting documents. So ultimately, we went to the creditors with what little information we have. They stridently opposed the restructuring. There's no change to the terms, notwithstanding a meeting on the 10th of October 2023. There's no new offer, and there's essentially no capital injection in the form of anything of worth to creditors. All they have is flex or OX tokens. So ultimately, Your Honor, I don't think it's right to say that either we are holding it up or that there's ongoing discussions. There's really nothing more. This restructuring plan has been considered. We put it to the creditors. They are clear. The answer is no. And it's not a matter of us trying to be difficult or what our view is. This is the state of play. Your Honor, I then come to the final point on alternative liquidators. And I say this again, I'm not taking issue with my learned friend, Mr. Kwa's conduct, but rather the conduct of his clients, or rather his client, Mr. Lee. Your Honor will recall that CWU 94 was initially fixed to be heard and was in fact heard on the 7th of August 2023. Mr. Simon Lee opposed CWU 94, but tellingly, Your Honor, he did not propose any alternative liquidator. He didn't say, if liquidation is granted, I want someone else. And in fact, he knew even earlier that a winding up application would be filed because, Your Honor had directed the IGMs to file the winding up application. So Mr. Lee has had more than 6 months to identify alternative liquidators if he so chooses, or even to say that he intends to put forth alternative liquidators. He didn't, Your Honor. It is really only in an affidavit filed the week before this hearing that he has now said, oh, actually, I want an alternative liquidator. Your Honor, this is a pattern of conduct that unfortunately has happened more than once. Your Honor will recall at the last hearing, again, in the week before the hearing, suddenly there's OA 792 being filed and CWU 94 has to be adjourned. So unfortunately, Your Honor, I don't think this application for alternative liquidator is made in good faith. It is unfortunately a continuation of the director's attempt to remove the IGMs for doing their job. And Your Honor, 3 issues were raised by my learned friend, Mr. Kwa. The first I can dispose of very quickly. This is in relation to the disposal inquiry. Your Honor, I was involved in that. The characterization, and again, I don't fault my learned friend because he was not involved in that, is completely wrong. Your Honor, that is a disposal inquiry determining the issue of possession. There is no determination on constructive trust or who owns this 10 million in cryptocurrencies. There is an originating claim that has been filed by the IGMs against the Samtrade liquidators. And this issue of who owns the 10 million crypto is going to be determined in that action. And Samtrade has very reasonably undertook not to dispose of the 10 million crypto or to distribute it pending the determination of that originating claim. So there is simply no loss and there's no negligence or anything of the sort. It is really just a disposal inquiry that disposed it in terms of possession to one party. So that is totally spurious, Your Honor. The second issue with FTX. Your Honor, FTX, this issue was raised in the applications brought by Mr. Lee to remove the IJMs. It was determined by Your Honor. It was dismissed. Mr. Lee did not bring any appeal against that application to remove the decision to applying to remove the IJMs. But Your Honor, more importantly, if Mr. Lee felt that something was really done that was wrong and the company has suffered loss, Your Honor will recall that at that hearing, I had raised that Section 115 of the IRDA allows a creditor to seek to bring a claim against the IJMs for misapplying company's assets or wrongdoing. It has been months and months since that application. No action was brought. So, Your Honor, this is an attempt to revive a closed issue because the directors are unfortunately, again, just trying to get rid of IJMs who have done an investigation and who are looking into their conduct. They want someone fresh to come in. So, Your Honor, I think it is not in good faith. FTX really is a closed issue, and that if there was any issue, they should have done something. The flag transactions, Your Honor, is even more egregious because, Your Honor will recall, the whole reason this company, this group, even has flex tokens, an illiquid and thinly traded token that has dropped significantly in value, is because the directors had gone behind the IJM's backs to enter into this transaction. My learned friend, Mr. Patrick Ang, has already mentioned how, in terms of the timing, it sounds a little bit too serendipitous. The directors caused 20 million of liquid USDT to be converted into these flex tokens, and weeks later, there is an OPNX offer saying, oh, I'm coming in to save this company. It sounds a bit too serendipitous in my respectful submission. And Your Honor, if there's any loss created by this flex transaction, it is because the directors chose to do this transaction. And we're not even saying the IJMs needed to approve it. But why didn't they even tell the IJMs that they were intended to enter into this transaction? It is a matter of the IJMs being in charge of Hodlnaut Singapore, not only the sole shareholder of Hodlnaut Hong Kong, but the largest creditor of Hodlnaut Hong Kong. Why do this transaction behind their backs? Secondly, Your Honor, in terms of the loss that my learned friend says resulted from this flex transaction, it's not so much the purchase of flex, but this issue of missing the deadline for converting flex to OX. Your Honor, this claim, I'm not sure what kind of claim it is, because all the IJMs did was to appoint nominee directors to the board of Hodlnaut Hong Kong. As a shareholder of Hodlnaut Hong Kong, sole shareholder, Hodlnaut Singapore clearly has a right to appoint nominee directors to the board. I'm not sure what kind of claim arises from appointing directors to the board. If the claim is that the directors were slow to respond, that is not a matter that concerns the shareholder. If anything, it concerns the directors. But I'm not saying the directors of Hodlnaut Hong Kong committed any wrongdoing. Far from it. Your Honor, in terms of the reason why the IJMs had to take this act of appointing nominee directors to the board of Hodlnaut Hong Kong, it was because the directors again went behind the IJM's back and concluded another transaction, this time the Razor transaction, converting once again liquid assets of the group into this speculative, illiquid, thinly traded token. And Your Honor, my learned friend says there is bona fides. They didn't do anything behind the backs. Your Honor, we have written letters which clearly show that in actual fact, what happened was the directors actively misled both the IGMs and this honorable court by claiming on affidavit that they were only in discussions about a potential transaction for Reza, and that they would update the IGMs and the court if they executed any transaction. It now appears, Your Honor, they already concluded the terms of that transaction before the affidavit that Mr. Zhu and Mr. Lee filed. This is serious misconduct in misleading both the IGMs and this honorable court, and it more than justifies the IGMs appointing the nominee directors to the board of Hodlnaut Hong Kong. I make one final point on this, which is that if the director's own case is that these assets belong to Hodlnaut Hong Kong, then any claim belongs also to Hodlnaut Hong Kong. And the claim would be against Hodlnaut Singapore for exercising its rights as shareholders. I've already said I cannot imagine what kind of claim this is, but that would not be a claim that is in any way released, because the claim would be against Hodlnaut Singapore. If Your Honor looks at the discharge that we have set out in our application for discharge as IGMs, the IGMs are not released from liability if they are negligent in the discharge of their duties in respect of Hodlnaut Singapore. So again, there's no issue. And it's not a matter of own self, check own self, because Hodlnaut Hong Kong, the party who has the claim, has the right to bring any claim that it wants. So again, I don't see an issue. Your Honor, these three matters that are raised are really not real or good reasons for appointing alternative liquidators. And Your Honor, I think it can also be seen from the fact that for a company with more than 16,000 users and creditors, and sophisticated major creditors who have lost a lot of money because of this company, the only people who are seeking to remove or replace or appoint a new person as liquidator, it's these two directors. There's no one else. So, Your Honor, that is the issue. If these were real issues and the IGMs have caused such terrible losses to Hodlnaut Singapore, you would expect that other creditors would have similar concerns. And certainly the major creditors who have lost more money and the major creditors who are sophisticated and advised by legal counsel. But you don't see that, Your Honor. Instead, you have these two directors whose conduct is already, if I may say, not above board, and Your Honor, directors who are being investigated by the Commercial Affairs Department of the police force for cheating and fraud offenses. They are the only ones trying to remove the IGMs and now trying to have alternative liquidators put in. This is not something that I think has any credibility whatsoever. My last point on why, Your Honor, perhaps the IGMs are best placed to be liquidators is the fact that this company has been in interim judicial management for more than a year. The IGM order, Your Honor, was made on 29 August 2022. The IGMs in this case have already done extensive work. They have a knowledge and understanding of the company that a new party coming in simply wouldn't have. And for that new liquidator, if appointed, to get up to that stage, there will be substantial time and cost that will need to be incurred to do so. There would need to be duplicative work. And the new liquidator, or rather the liquidator, if someone else is appointed, can't simply say that actually all the things that the IGMs found in their IGM report, I'm just going to adopt everything. They need to look into those issues as well and say, in my independent judgment, is this correct? This is all time and cost that will be to the detriment of the creditors of Hodlnaut Singapore. So if anything, Your Honor, it is completely in favor of the creditors if the IGMs are appointed as liquidators, because They are already in place with the requisite knowledge. They've already taken steps. They have filed proceedings, as I mentioned, against Samtrade liquidators. They are the persons who are best placed to conduct this liquidation. And with that, Your Honor, I would rest my submissions unless Your Honor had any other questions.
Right, thank you. None at this time. As I indicated, I will need to reserve judgment, but I intend to give my decision in about 3 weeks. I will deal with all the other outstanding, any other outstanding applications at that time. So CV for approximately 3 weeks, I will ask registry to fix a hearing for me to convey my decision, probably an hour or so in the evening. All right. So
Yes.
anything else that crops up in the meantime, parties may write in to alert me accordingly. All right. Otherwise, in 3 weeks' time.
Thank you, Your Honor.
Right. Nothing further from anyone this afternoon. All right. If not, court is adjourned.
Good day, Your Honor.
Good day, all. Thank you.
Your Honor.